CIPIC at Strathmore, together with his co-author. So Francis.
Thank you very much. My co-author Beatrice will start and then I will finish.
Okay, are you going to share a screen?
Yeah.
Great.
Okay, so my name is Beatrice, as I have been introduced, and our research was based on the exemption of national security. Just give me a minute so that I can project the slides. Yes, so today we're going to be presenting on the exemption known as national security. We were looking at how security laws hinder the development of Kenyans' privacy consciousness. So this is just a general brief outline. We will be looking at the introductory part will basically be focusing on what exactly the Data Protection Act provides for and the exemption itself. We will also be looking at the various factors which has affected how Kenyans relate with privacy. And we will also try to address what norms should be adopted in order to ensure successful implementation of data protection laws. So in 2019, Kenya enacted the Data Protection Act. The law contains a specific exemption under Section 51(2)(b) that provides that the processing of personal data is exempt from provisions of the Act if it is necessary for national security or public interest. So the Oxford Dictionary currently defines national security as a safety of a nation against threats such as terrorism, war, or espionage. We also looked as to what scholars define national security as. And when you look at Samuel Makinda, he argues that institutions, principles, and structures associated with society, as well as its people, ought to be protected from both military and non-military threats. And this is usually what is referred to as national security. So the Kenyan Constitution defines national security as a protection against internal and external threats to Kenya's territorial integrity and sovereignty, its people, their rights, freedoms, property, peace, stability, and prosperity, and other national interests. The exemption of national security is usually a tool used by security agencies to carry out their duties in now protecting the country from these internal and external threats. So the issue usually comes in that you have the objective definition of national security, but the state itself is not separate from the people or the regimes which govern them. And these regimes always determine what at a specific space and in a specific space and time, what will be considered as a threat to national security. So this actually leads us now to the relationship between privacy and national security. When you look at the origins of it, or where you can first link where there were laws guarding against privacy, you can check in colonial America. You see that the founding fathers at that time were quite disgruntled with the manner in which writs and laws were being used to invade the privacy of their homes. So this eventually led to them including in the US Constitution specific amendments to prevent the arbitrary search and seizure of their homes. And you have this continuing up to today, where you see with every development, they're also trying to guard against intercepting of correspondence. So, and you find that with increasing technology development, there's also a need to continuously protect people's information through their communications, their own homes, And as we're coming into it, also increasing surveillance from both government and industry. And you can see that the main interest in collecting all this information is that this kind of information helps industries and states to make certain decisions. And it also helps specifically states to further their functions of national security. So a few months before the enactment of the Data Protection Act in Kenya, a survey by CG, Ipsos, supported by UNCTAD and the Internet Society, found that the lowest level of concern was by Kenyans at 44%. So what exactly is the dilemma? Just like access to information laws here in Kenya, which have had a low implementation rate, the data protection laws need intentional and active citizen action, in the absence of which the law itself might actually fail in doing what it seeks out to do. So privacy consciousness is a key component to the successful implementation of the Data Protection Act. So which factors have contributed to Kenya's low concern for informational privacy? So the first, which we link way back to the pre-colonial era, is that Africans tend to have a sense of communalism. And this is usually predominant amongst most individuals in a much more silent way. And it can be argued that it is still there, especially in sectors which are rural. And the second factor is national security. So what we are specifically looking at is how probably national security has contributed to a culture of permissiveness. We're also investigating the role Kenyan security laws have played in the creation of this specific culture, and whether this culture now will affect the implementation of the Data Protection Act. So I will give my colleague Francis the floor to continue.
Thank you very much, Beatrice. If you can go to the next slide. So one thing we noticed while we were doing our research was that on the role on Kenya security laws, it all began in 1915 when the Kipande system was established by the Natives Registration Ordinance. So Kipande in Swahili is it's an ID, and it was being used to control the natives, as Africans were then termed as, to control their movement and to put them in reserves so as to have their labor available for the colonial settlers who were in Kenya then. And then years later, the ordinance was amended and they started issuing IDs. And during the Mau Mau rebellion, the ordinance was further amended, and it included fingerprinting for especially around the central Kenya region where the resistance was really hot, and it involved the Mau Mau fighters. Next slide, please. So to date, while that was pre-colonial Kenya, to date we still have laws that allow for privacy intrusion and without a warrant. And such laws are like the Criminal Procedure Code, which allows a police officer to enter and search a place without a warrant. The National Police Service Act also allows a police to stop anyone or a vehicle and to search it without a warrant. The Preservation of Public Security, it also allows the police to search people and to enter premises. And the Food and Substance Act, it allows authorized officers, so they do not even have to be police officers, to stop vehicles and vessels and conduct a search to pick samples. The other act which also allows for searches is the Private Security Regulations Act, which also allows private security to engage in searches. Next slide, please. The other group of laws that we came across in our research was the laws that allow security agents to ask people for identification. documents, such as the Registration of Persons Act, the Kenya Citizenship and Immigration Act. That one allows carriers, these are like airlines and buses, to ask for identification documents, immigration officers in the course of their duty, and any business or person offering accommodation services. The Private Security Regulations Act as well empowers private security service providers to ask for identification documents and to record them and to even confiscate them for the period in which you're let's say, you're entering a building, and it will be returned to you when you're leaving the building. Next. Other laws that require people to give out the documents, the production is the registration of SIM cards law, which is contained in the Kenya Information and Communications Act, and the Proceeds of Crime and Money Laundering Act, which requires financial institutions to know their customers, and that involves them getting information about them from their card, from their identification documents, such as identification cards, passports, and others, and even birth certificates. Next. So there's a culture of arbitrary searches and police surveillance, and we feel like it has contributed to Kenya's low concern to information privacy. Garfield Benjamin said in his text, where he was discussing on how privacy is as a cultural phenomenon, say that privacy is a freedom that is linked directly to fear and a necessity for those deemed to be outcasts, deviants, and traitors. Before people's mentality shifted from tribal to individualism and enlightenment, privacy was deemed to be a necessity for criminals, assassins, and usurpers. And this was a defense against persecution. So to date, you hear the phrase, "you have nothing to hide," and it is used to counter pro-privacy arguments. And governments, while acknowledging that there's a right to privacy, you'll hear government security agencies say that you wouldn't be so fussy about the right to privacy if you have nothing to hide. So there's that aspect where if you resist searches or arbitrary searches, you're termed to be out to hide something, or you are a wrongdoer who is not helping the security agencies in doing their work.
That's 12 minutes. You've got 3 minutes.
Okay. Next. So what's the way forward? The way forward is developing a privacy consciousness in the Kenyan society. And consciousness is developed from awareness. Kenyans need to know that they have a right to privacy. According to certain scholars, the indicators of law awareness include law awareness, acquiescence, attitude, and behavior. Next. And we did a short survey where we found that 53.2% of Kenyans are aware of privacy laws. However, out of all our respondents, only 45.9% of Kenya did not know about the rights and obligations in the Data Protection Act. So there's a sense of people knowing that they have a right to privacy, but they do not know what it entails, and therefore they cannot take any action. Next. So the solution that we have found is in the Data Protection Act. In Section 8G, one of the functions of the Office of the Data Commissioner is to take measures such as to bring the provisions of the Act to knowledge of the general public. Therefore, it is the work and the duty of the Data Commissioner to educate the citizens on the provisions of the Data Protection Act, so that to empower them to be able to participate in enforcing and in in the implementation of this act. Thank you.
Thank you very much. So what questions do we have for Francis and Beatrice? I see a complicated question from Silas in the chat group. And someone is asking for the slides. Let me start off with a question for you then. Sometimes when we're doing survey work, we ask simple questions. Do you have a mobile phone? Do you not have a mobile phone? Can you afford to top it up? Those sorts of things. When you're asking the questions you ask and the question UNCTAD asked, what really are we measuring? It's the perception of the security of the data protection? Or is it what value do we place on people saying, yes, I feel secure or I don't feel secure? I come at that, so I should say, I come at that from someone who sometimes works in the field of corruption. And one of the questions there is perception of it. Francis, Beatrice?
If I could answer that question, I think specifically in our survey, what you were trying to maybe try and look at or try to find out was mostly on their perception. It wasn't necessarily to dig. We also have like a much more in-depth questions to also try and like weigh out when you say yes, what did you mean? Also, we also try to find out if the people besides their current perception, which they're telling us, how willing they are to take action and what factors they're considering to take that action. So in our survey, we really tried to go beyond the yes and no and to try and get more specific responses from the respondents who we got here.
And that presumably will have to feed through into education campaigns. I don't know if you've seen the question from Silas.
Yeah, I've seen the question from Silas. And he mentions that in the Data Protection Act, the Kenya Data Protection Act, there's the definition of DNA. And in the Nubian Rights Forum case, which was decided early this year, the court prohibited the government of Kenya from collecting DNA and GPS of people while implementing the Huduma Number project. So the definition of DNA is there because DNA is part of personal information. It's a biometric, and biometrics have always been personal information. If you look at the definitions in data protection laws across the world. So for that particular project, the Huduma Number project, the court already gave directions, and the government hasn't appealed against the collection of DNA. So despite DNA being in the Data Protection Act, doesn't mean that they will have to collect it because the court already pronounced itself and prohibited government from collecting DNA.
That's great. And I see you've put your presentation up into the chat for anyone who wishes to download it.
On the question of the Data Commissioner, yesterday in the National Assembly, the President had given out the name of the lady who will now be the Kenya's Data Commissioner. Her name is Okay, she was appointed yesterday. I'll write the name once I remember it. Yeah, so we hope that there will be some action after she's vetted by the National Assembly and sworn in now as the data commissioner. But yeah, because of no data commissioner office, therefore no one to implement the functions of the data commissioner office as required by the law. There's also, we believe that that's also a contributing factor to the low awareness to privacy and data protection rights.
That makes sense. Are there any more questions? Can I ask one final question before we go on to Thompson? One of the arguments made about SIM card registration is that it's very useful for the police and the security guys. Do we have any maybe statistics about how much they use this? Or do we have cases where they've used SIM card registration data to help the prosecution? Or do they just say they want it for prosecution?
My experience as a researcher on this it's been hard to get statistics from the Office of the Director of Prosecution on how many prosecutions have been done on using certain laws, because if you are to prosecute for fraud over a mobile device, there are certain laws which you would have used. So it has been hard for us to track, to know the number of cases which have been successfully been prosecuted using certain laws. And therefore, in measuring the success of the intentions of the SIM card registration has been hard, because there's not been any tracking mechanisms in terms of prosecution and in terms of prosecution.
Right. That's great. If there are no more questions, we can.
One more question.
Yeah.
Hello. Yes. Brian here.
Who is speaking?
This is Brian Chitio from Zimbabwe, located in Atlanta. My question is about the SIM cards too. So each and every SIM card you purchase in Kenya, you have to produce ID and register, or just one time? It's a one-time process when you buy one SIM card.
So each and every SIM card you buy, you have to register. They take your photo, you have to sign digitally, and they keep a copy of your identification document.
And you said it's kind of difficult right now to acquire information on actually how much it's been helpful in prosecution cases. It's really... Okay.
Yes, I've reached out to the Office of the Director of Prosecution asking for some statistics, and it was hard for them to get it, because I don't think they've been recording like which crimes they prosecute under which laws.
Because I'm in the mobile software development industry, and that could be very dangerous down the road, as companies like Huawei and certain other Nokia companies are really doing dangerous things with acquiring information that early in buying a device or tools that work with the device. So it's actually a very potent and dangerous method that need to stop. 90% of the countries around the world, you don't need to register anything when you just purchase your SIM card from a grocery store or places that send. That initial collection of data right away spills into your data being sold faster and being accessed easier, either by hackers and so forth. So yeah, it's got very negative connotations. So I just wanted to know if it registered every SIM card you bought. But thank you so much. Great presentation, guys.
You're welcome. Thanks so much.
Thank you very much, Francis. and Beatrice. And we will now go to Thompson, who's a European Research Council Fellow at the University of Southampton, who's going to talk to us about autonomous weapons. Thompson, off you go. Going to share a screen with us? Is that working?
Thank you very much. Apologies, I was trying to find my unmute button, which had just disappeared. And Chair, through you, Chair, Prof. Ewan, thank you very much for chairing this session and allowing me time to present today. Nevertheless, before I proceed with my own presentation, if you may allow me through Chair, I tried earlier to raise my hand during the presentation of Beatrice and Francis. If I may just ask a question, they are free to answer at any other time, perhaps after my presentation or in the comment box, if that's okay with you, Chair.
Yeah.
So Beatrice and Francis, thank you very much for your presentation. The question that I have for you is that I see that in your discussion of issues of national security, you referred to some African values, but particularly the issue of African communalism or African communitarian ethos, which is really something of interest to me. I wondered, which is my question, if adopting some sort of an African approach that is characterized with respect to African values or how the African people live when we are dealing with national security is a bad thing in itself? Or is there a need, for example, maybe to strike a balance between the issue of African, of national security of African states and also respect of African values as it were? The reason why I asked this question, I am wondering from your perspective, if perhaps there is a need to kind of resist an urge for a wholesale adoption of Western approaches when it comes to national security? Or are we supposing that when we're dealing with national security and data protection, there is some sort of a universal approach that needs to be adopted? That would be just my question, which perhaps you can answer in the chat box or later on. Without wasting further time, I would want to proceed with my presentation, where I'm focusing on the link between our data and the development and use of autonomous weapon systems. Before I start on my presentation, I would want to start by playing for you some views from scientists across the globe on the issue of autonomous weapon systems before I go into my own discussion. And the video is about 5 minutes, which will make my conversations with you between 12 to 13 minutes or so. Thank you very much. I'm hearing there is no sound on the video.
Yes, there's no sound, Thompson.
I do not actually get how that is, because there is actually sound on my side.
It's on with your presentation for the sake of time.
Hi, Thompson.
Hello.
Try the following. I don't know what audio settings you have, but under the microphone where it's written mute, if you span up there, just make sure that your speaker system is the same as the system. So it should be the first option if you're using them on OS machine, or the second option, but it says same as system. Just make sure it says that, because it might be different there.
Okay, so what I'm going to do, thank you very much for the intervention. What I'm going to do is that I'm going to first proceed with my presentation. Then at the end of my presentation, I'll try to see if I can replay the video, and perhaps by just removing the earphones and also doing what you just suggested, and see if it works for the sake of time. Thank you very much. Not sure what's happening here. Oh my God. Now I cannot find, are you still seeing my PowerPoint?
No, we're seeing you.
I think maybe I need to reshare the screen.
And above you, it says that your network bandwidth is low.
So I'll try to, okay. Can you see my screen now?
Yes.
Okay, sorry about those hiccups. Perhaps it's a sign why I do not trust, these kind of machines to make, far-reaching decisions as, deciding who lives or dies, because there is usually these mistakes or these glitches when it comes to use of technology. So my debate or my discussion today is to focus on the link between our data and the development of use of autonomous weapon systems. And I would want to start perhaps by going directly to the issue of definition of what are autonomous weapon systems. Autonomous weapon systems are robotic weapons, which once activated, are able to make the decision as to who to target, who to use force against, and with what severity, without any further human intervention or control. These kind of weapons, so to say, raise serious legal, ethical, moral, and national security concerns, which have been a worry for the international community for almost a decade now. Now, the discussions actually which are currently happening on this issue of autonomous weapon systems, particularly within the United Nations, started there because of a report that was submitted by Professor Christopher Haynes from the University of Pretoria at the UN Human Rights Council sometime in 2013. Now, these autonomous weapon systems, in particular, how they are linked to the issue of data, is that their development depends on the training of these particular systems on our data. In particular, our faces, how we react to certain things, our cultures, only to mention a few. That particular data at the current moment is gathered through other civilian uses of our data. For example, the data that is gathered by Google, Facebook, Microsoft, and other companies as it were. Now, the autonomous weapon systems, when I say that once they are activated, they're able to make the decision as to who to target. They use particularly facial recognition technologies. In particular, your face, my face, or anyone's face may be programmed in a particular algorithm that perhaps this is a legitimate target. When you find that particular individual, you are supposed to terminate or to use force against that particular individual. Of course, the concern is that there are various legal issues and legal considerations, legal judgments, moral judgments that goes into the use of force. For example, considerations such as that by the time you may be found, perhaps you are no longer posing a threat that you might have posed at the initial stage when that system was deployed against you. Now, we then see a complete link here between the use of our data, which we may provide to certain state actors or non-state actors for certain purposes. But that data may then be used actually to contravene or violate our rights, such as the right to privacy, which is actually the lower threshold of the violation here, because it may actually result in the violation of your right to life. Now, it will be a sad scenario, at least in my view, to find that while your data may be accessed in a way that or accessed and used in a way that you did not anticipate in the beginning when you provided that data, and then that data is then used to violate your another right, that is the right to life, which is a really far-reaching concern. Now, you would see that when the discussion on autonomous weapon systems started within the international community or the United Nations in particular, various states across the globe, including African states, have made submissions, particularly to the United Nations Group of Governmental Experts on Lethal Autonomous Weapon Systems, making it clear why perhaps they do not want these kind of weapons to be developed in the first instance. And among African states, Zimbabwe, Ghana, and many other smaller nations across the globe who have emphasized that they do not want the development of these particular weapons. The argument which they use is that, particularly African states, is that the use of those particular weapons will violate the right to dignity, that it is undignified, it is against the spirit of Ubuntu, to let a machine decide who lives and who dies. Now, what I wonder is whether then African states, or African frameworks on data privacy, laws and ethics are alive to the link between the development of autonomous weapon systems and protection of personal data. The laws that I'm looking in this particular chapter are a number of African countries, particularly those who have made it clear in their foreign policy that they do not approve the development and use of autonomous weapon systems, is that I see a disconnect. There is no link, so to say, between their position at the international level or their position in general regarding the development and use of autonomous weapon systems and the laws that they are passing regarding the issue of data protection. I'll give an example. For example, if you look at Zimbabwe's data and security private bill, which is still in discussion starting in 2019, you would find that they particularly mention issues of concern when it comes to data protection. And one of the things, or two of the things which are core is issues of xenophobia and racism. That, the data age, or our data, how it is being used, particularly in the digital age, is posing very, very serious concerns, or is actually exacerbating situations of racism, situations of xenophobia. So these are the worries which they particularly and expressly mention within that particular law. Yet Zimbabwe, regardless of it being the first country actually at the United Nations, the first African country, so to say, to clearly articulate its position that it does not approve the development of autonomous weapon systems and their use, you find that there is no mention there within that particular law or the particular bill which I just referred. And if you look at also other countries across Africa that have supported or that have taken the position that we should not develop autonomous weapon systems, again, they are silent. The laws and ethical frameworks that they're developing, they are silent of that potential link between development of autonomous weapon systems, which they disapprove, and protection of data. Now, the question is that how is this actually important for nations to be particularly aware of these things or alive to these issues? Is that when I look at African governments, what I try to assess, one of the discussions that I have in this particular issue is that it appears as if African governments are not alive to the link between foreign Western investments in AI technology, particularly those that refer or that rely on personal data, and their foreign policy or their positions on the development of autonomous weapon systems. I have a number of various Chinese and other Western companies that have started to invest within the African continent. And of course, when these particular companies are welcomed on the African continent, it is under this belief, which is correct, because there is dual use of AI technologies, that when they are given these technologies by, or when they make deals, business deals with these Western companies, it is like for other purpose. You are told that, you'll be able to police your citizens in a better way. You'll be able to do this with this particular technology. And among those technologies, or what is rampant, is facial recognition technologies. And there is an a very interesting report that has actually been then made regarding the investments of these companies in or on the African continent, where someone actually reported that the big brothers or these companies are seeking African faces for their own purposes. What do they mean when they say they are seeking African faces? Because one of the limitations that has been noticed in the development of autonomous weapon systems has been that these weapon systems are performing badly when it comes to recognizing African faces or faces of Black people, because the data sets that have been used or that is being used to train some of these machines has been like that more fully able to identify white faces. But when it comes to other faces from other regions, they are performing badly. And the explanation behind this may be that the data that has been largely perhaps accessed by these companies from this other side of the world are of other races, not necessarily in bulk of Black people or African people, so to say.
We are running out of time, Thompson. It'd be good if you could come to a conclusion.
Thank you very much, Prof. Ewan. I'm actually coming to my conclusion, where I ask this question as a matter of discussion, where then I consider this aspect, where I say that one of the critical points that is mentioned is that the autonomous weapon systems, or the development of autonomous weapon systems and their use, may result in exacerbation of racial discrimination. And the criticism is that the data sets that are being used to train these machines are not diverse enough. The question which I then ask from a teleological ethics standpoint is that if the reason behind these weapon systems performing badly is that they don't have a diverse set of data sets, could there be then perhaps an obligation or a duty on the part of African governments and everyone else to provide that data? And my conclusions on that is that perhaps there is no one who is actually obligated to contribute to the violations of their own rights, as it were. So there would be no such obligation, and perhaps African states should continue to be aware of that particular link which I'm mentioning between the development of autonomous weapon systems, which some African states have clearly said that they don't want, and the protection of data. On that, I would want to end and thank you very much for your time.
Thank you very much. Do we have any questions?
Yes, more part of a question and part of a suggestion. Dr. Changeta, thank you so much. Again, my name is Brian Chitio. I'm also a Zimbabwean. I think this also comes down to participation of African governments, because we can truthfully be honest with each other and say nothing is going to stop the progress of those weapons. They are coming. The problem that's going on that can actually assist governments on our continent to maybe render or soften the situation is if some of our governments stop the practices they do to suppress internet access or suppress access to technology, so African developers can start participating in these things. We can create our own software languages. We can create part of AI development softwares that can defend ourselves if we are to be forced to do things. I actually didn't know that Zimbabwe petitioned something like that to the UN, Mr. Chengeta. Thank you for that information. That's wonderful. As a software and AI developer, we will not stop these weapons. The quicker we start participating, the better the situation is going to be. Now, a quick question, Mr. Chengeta. How far, or do you know of any companies that are already operating in Africa right now, as far as autonomous weapons?
Okay, can we I see a long question from Emma. Does Emma want to ask that?
Right. Hi, Thompson. Nice to see you again. My question relates a little bit to Brian's question. What do we do with regards to transnational companies, the ones that you refer to, the Western ones, but there are surely other ones also in Africa, not just Western ones, Asian ones as well. Okay. What do we do about them? If we talk about member states and the African states and African Union, the United Nations and so on, these kinds of the international law and international humanitarian law apply to member states, not to the private sector necessarily. And so we have this standoff in terms of data sovereignty, in terms of digital sovereignty, between governments regulating, but the companies having the creative power. And governments want these companies in their country. So what do we do with the legislation? I hear everything that you say and you ask very pertinent questions, but what do we do in terms of the law? Thanks.
Okay. The law in...
Can we just add one specific element to that, Thompson? There's quite a lot of Chinese companies, particularly CCTV companies, operating in Africa. It may be worthwhile commenting on that. If you want to try and answer all of those difficult questions, off you go.
So, thank you very much for the question. For the questions, I will try to answer them. I hope I will remember all of them. Starting with Brian. Thank you, Brian, fellow countryman. The question which you asked, I think I should start perhaps by emphasizing this aspect when you talk of almost the inevitability of autonomous weapon systems that they're coming. I want to respectively perhaps decline or discourage that approach. That when it comes to issues, particularly, it's only that in this discussion I didn't have much time to discuss the reasons why these weapons should not be allowed actually to come into play, and some of them, lie at the heart of what actually it means to be human, issues of accountability, issues of trying to discourage racial discrimination, issues of discouraging continued oppression and domination of one people by another people. And because of that, I would want to think that if the international community actually acts, it is inevitable we can be able to stop autonomous weapon systems, particularly those that have autonomy in their critical functions from coming into play. And the question which you also asked about participation of Africa, it's a very important point. And I'll mention it in this regard, that when I look at participation of Africa, I look particularly as an issue of Africa participating in the formulation of policy on how to regulate these kinds of AI technologies. I think Professor Emma, she's part of, I think she's chairing a UNESCO group that is looking actually on the issues of formulation of policies on AI technologies. And one of the issues that is emphasized therein is an aspect of diversity and inclusion, to say that there is need to hear the views and values of everyone across the globe so that we may come up with better policies. I wouldn't necessarily then want to think of participation only as we need to develop our own autonomous weapon system so that we can be able to defend ourselves. That may be looked as a good idea, but practically it's first not a good idea for humanity as a whole. if these things come into, or this kind of weapons come into existence. And secondly, I'm not sure if many developing countries, like Zimbabwe, our country, will be able actually to develop these weapons. I mean, my reason is that if you look at how, or the satellites which will be used and other things that will be used by these technologies, I'm not sure if the big powers will even allow you to access those kind of technologies to begin with. There's something with nuclear where you find that there are certain rules that are put into place. So it will be only certain powerful states that will possess the weapons, and they will use them the same way drones are being used across the globe, and not necessarily in the European and Western regions, which is actually another discussion by itself. You then asked, I think it was a question regarding, which is the same question also linked to Prof. Emma's question about companies that may be already in Africa. And in this regard, it's not necessarily companies that are developing autonomous weapon systems, but whose businesses, particularly regarding facial recognition technologies, is essential to the development of autonomous weapon systems. We have CloudWalk, which is a Chinese company that actually signed a deal, a mega deal. You know the issue of mega deal with our government actually in 2019, the government of Zimbabwe. And this is a Chinese company, and China is one of the companies, one of the states, sorry to say, which is developing this particular weapons. And CloudWalk is about gathering, it's facial recognition technology. And you do not know, once your data has been mined, what is going to be used. And my suspicion is that it is to contribute to the development of autonomous weapon systems. Again, we have Google, which has been Project Maven. Project Maven was specifically issues of development of autonomous weapon systems. Google opened its offices also recently in Ghana. And Ghana is part of other African nations that have said we don't want autonomous weapon systems. As to how Google is using those, whatever, you're again not sure what is happening with over there. In South Africa, one of the biggest facial recognition and CCTV companies, Hikvision, has now its one of its headquarters in Johannesburg, in South Africa. And it is, how these companies are then having access to African data and how they are supposed to be using, which I think should be properly regulated. And African governments should be more deliberate to say, we know this is what's going to be happening, but these are the things which we don't want to end up. And among the issues of data protection should include the issue to say, you should not be using, or there should not be use of this particular data for purposes of development of such kinds of weapons, which we don't want to come into account. I lastly want to address, sorry for taking time to answer these questions, the concern of Prof. Emma, which is very, very fundamental. When you say the power, of course, of creation is indeed with the private non-state actors in this regard. And I would want to give an example on as far as approach of regulation, how you can be effective when you're dealing with non-state actors who are holding much power. I know you may have heard of the Kimberley process, the issue of blood diamonds. Governments struggled for a long time trying to come up with some sort of regulation or some sort of how to deal with the issue of blood diamonds, and they were doing it just as states, and they were not succeeding. It was only during the Kimberley process when they decided to take companies that are involved in the processing of those diamonds, making rings, and then made rules that you shall not be accepting, particularly issues of diamonds coming from conflict-ridden regions and etc. All those arguments that we saw that the process started succeeding. Along the same lines, the suggestion would be pressure should be also continuously, we should also not only pressure, be inviting, Facebook, Google, and other, as what is already happening in the other side of the world, on the table when we're discussing issues, to make sure that when we make laws, they are also binding and they're also our way. And I should say, I'm happy, as my last statement, forgive me, Prof. Ewan, I'm happy that many scientists working for these companies, I have colleagues, the likes of Nora Lolan, who was working for Google, who are quitting. They have jobs, well-paying jobs, to say the more they were many scientists in Google will say, if you are going to use people's data, or if you're going to use our expertise to develop this kind of weapons, we cannot work for you. So the fact that scientists who work for these companies are coming on board is another important aspect as far as approach and regulation when it comes to non-state actors. I hope I have attempted to answer your question, Prof. Emma and Brian.
That's great, Thompson. Can you do two things for us? One is stop sharing your screen. And the other is, can you put your slides into the chat so that people can get the slides if they want to listen to the video?
Okay, let me do this.
In chat, there should be an option. And then we can pass the presentation over to Amanda, who is from the University of the Witwatersrand, amongst other things, and Digital Law House, who is going to try to bring together for us both data protection and cybersecurity. So, there are the slides already from Amanda.
Okay, and then I found my unmute button. Thank you.
That is the crucial thing. All you have to do now is put that into presentation mode, and you're away.
Okay, perfect. Thank you so much, Professor Sutherland, for that. I am Amanda Manyame, as you have said, and today I will be exploring the relationship between cybersecurity and data protection. Francis and Beatrice touched on this a little bit, so I'm going to go back just a bit at the beginning of what exactly is their relationship to begin with. What is data protection? What is cybersecurity? Where do the two merge? And essentially, why should we care? Is it an issue to begin with? So if you want to understand this tension between cybersecurity and data protection, you have to firstly understand what cybersecurity is, as well as what data protection is. So to define that, I will simply just define data protection as a type of informational security that deals with the proper handling or managing of personal data. It is in terms of every single piece of legislation that we have on the globe, it only deals with the protection of data that refers to a specified person or an identifiable person. In some countries, such as South Africa, it also refers to an identifiable organization. Cybersecurity, on the other hand, refers to any measures, policies, tools, what have you, that are taken to protect computer systems against unauthorized access. Such attacks would be examples: denial of service attacks, phishing, malware, data espionage. So essentially, what happens is, when you're dealing with personal data, this is information referring to a person or an organization in some countries that is being housed in a computer system. You can call it an ICT system, you can call it an information system, but as long as it's on a computer and it's not being held in an office somewhere in hardware or on a piece of paper, that's the information that we're referring to. So as long as you have that data being housed on a computer device, that is what is being protected in terms of data protection laws. And then when you look at what is being protected with regards by cybersecurity, it, amongst other things, includes that data as well. So cybersecurity, in essence, protects companies against having individuals that do not have the right to access data from being able to access that data. So if you can see, there's an intersection between cybersecurity and data protection. Firstly, it is protection of the data in that computer system. And secondly, it is the fact that the person responsible for either the computer system or managing that personal data held in the computer system are held to account for any breach that may occur. So why is it an issue that these two intersect, and where do we find these tensions? Firstly, the biggest tension, it comes from the fact that cybersecurity laws or regulations also provide for cybercrime. So when an individual unlawfully accesses, whether it's hacking or in some other way, accesses a computer system and they gain access to that information, in a number of countries, that would be a crime, and it is covered under cybercrime laws or cybersecurity laws. And there are penalties for that, whether it's imprisonment or it is a fine. So this is the biggest relationship that you find. And as a result, one of the reasons why there's this tension between the relationship between data protection and cybersecurity is because under the name of national security, communications belonging to citizens and countries are intercepted unreasonably. And as a result, your right to privacy is infringed upon. So in the research paper that I conducted, there are several issues that arise as a result of the intersection between data protection and cybersecurity. Here, for the sake of today, I've only looked at 3, and I'm going to look at a case study, one specific African country that deals with these 3 particular issues. So what comes across is you find legislation both dealing with data protection as well as cybersecurity or cybercrimes does not clearly define certain terms. You find that there is a lot of state surveillance under the guise of national security or in the interest of the public. And then you also find that the application of data protection laws in African countries that have data protection laws is not applied equally, it's not applied fairly. There are a number of issues that come across. So let's look at Uganda as an example. Uganda's Regulation of Interception of Communications Act 2020 empowers law enforcement to intercept electronic communications in an effort to deter cyber breaches or crimes so as to preserve national security as well as in the interest of the public. In essence, this act allows for state surveillance in the name of the public's interest and national security. Such a provision can be found in several other countries' regulations. It can also be found in the Budapest Convention, which at the moment is the leading authority on cybersecurity and cyber crimes. Even though only 8 African states have ratified it, it has informed a number of provisions in several in-country policies and laws that deal with cybersecurity as well as cyber crimes. Notwithstanding such surveillance and investigative powers, there needs to be a limitation on how these investigative powers or this power to surveil electronic communications is dealt with so as to avoid any limitation on human rights, in particular, the right to privacy, in particular, data protection. So in such instances, you find that the Budapest Convention states that state surveillance is allowed provided that it is necessary and it is proportionate. So what has been observed in Uganda is that in the Regulation of Interception of Communications Act, it does not clearly define terms such as national security. It defines the term national security as matters relating to the existence, independence, or safety of the state. And therefore, if the communication or threat of the communication falls within this arguably broadly defined statement, then law enforcement is allowed to intercept electronic communications. And when you apply this, you find that during 2018, and surprisingly only reported in 2019 by the Wall Street Journal, you find that in Uganda, there was a former entertainer that was now based in the US and was apparently now a politically active individual, Bobby Wine. His WhatsApp and Skype communications were intercepted. Initially, state intelligence officers attempted to do so over a period of 2 days, failed, and they later approached Huawei technicians, and Huawei in terms of this act, had to intercept his communications and provide such communications to the state. Further to the definition of national security, you find that in this RICA Act, it also empowers a judge to grant a warrant for the interception of the communication where there are reasonable grounds. In terms of the provision, the judge needs to apply their discretion in determining whether or not there is a threat to national security. And as I have already said, national security is so broadly defined that anything could be a threat to national security. As a result, because of how badly drafted the definition of national security is and the broad powers that are given in Section 5, a judge can issue a warrant for law enforcement to be able to intercept communications, and they essentially just have to meet a very bare minimum. So what does Uganda's Data Protection and Privacy Act 2019 state? How does it then protect against such breaches on the right to privacy, considering that Uganda is one of the countries in Africa that has an effective data protection law? It's been effective for a little over a year. According to Privacy International, this act is not being properly implemented as it stands. This is as a result of there certain measures that were meant to be put into effect once the act came into effect, but these measures have not been put into effect. And also you have one of the issues or one of the concerns raised by Privacy International being that there's unregulated data processing that is still going on. So you will find that even though you have a data protection act in Uganda that echoes the same provisions that you have in, for example, the GDPR, that you have in the OECD guidelines, that you have in virtually every other data protection law on the globe, you will find that the application of the Data Protection Act is not necessarily being applied in a way that protects personal data in instances where the state feels that there is a risk to national security. Therefore, they want to be able to surveil your communications, and your communications, which are essentially your personal data. Moreover, you're finding that in Uganda, there's this prolonged...
I'll just assume everything is good.
There's this prolonged delay in the effective implementation of the Act itself. And without such implementation, personal data will continue to be open to abuse under the guise of national security or any other regulations that allows for the surveillance of citizens' electronic communications. Additionally, the data protection law in Uganda provides all the standard protections. However, still it's the application that is the problem. So even if, let's say in a perfect world, if the data protection law in Uganda was to be applied properly, taking into account all the protections and all the rights that are afforded to data subjects, would it still be able to protect personal data in such instances where the state feels that there's a threat to national security? I would argue that once information is collected for ill purposes, it is very difficult to remedy it along the way and ensure that this personal data is protected. So if you notice in every personal data protection law, the intention is to ensure that a data controller collects personal data with good intentions for a specific purpose, a purpose that is lawful in terms of, firstly, in international human rights, as well as data protection laws and best practices. However, if this doesn't happen at the collection stage itself, this personal data, once it has been collected, once it has been stored, it becomes very difficult for you to be able to go get back that personal data. You could argue that although an individual would have the right to be able to withdraw their consent, it might prove to be extremely difficult, particularly when it's your communications that are being surveilled. The chapter that I looked...
2 minutes.
Thank you. So at the end of the day, I think that this quote by Rebecca sums up the argument very well, that there's no country on earth where internet and telecommunications do not face at least one pressure from governments to do things that would potentially infringe upon the right to privacy. Thank you so much for this time. Over to you, Professor.
Oh, you had 2 minutes. You can speak for another minute or two. No?
I'd come to the end.
Okay. Do we have any questions? No questions. Amanda, you said that some of the legislation was, I think your phrase was badly drafted. I was wondering whether it was actually intended to be that way.
Well, that is a possibility, I would say. A number of African states have seemed to want to be able to surveil personal data. They seem to be able to see what their citizens are up to and to be able to essentially control the narrative, whether it is in the press or it's on social media. So you could essentially argue that. In my paper, I do look at countries that are at the bill stage of their data protection laws, because I do want to see, are we changing our drafting methods? Are we just copy pasting these laws as we're getting them from, let's say, the GDPR? Or are we putting some thoughts into it after there's been some public participation? So it does stand to see, but Zimbabwe is a very interesting case, considering that the Data Protection and Cybersecurity Act is currently going through the commentary stages. So we'll see if Parliament takes these comments into account, because those are some of the issues that are currently being raised. Are we intentionally badly drafting?
I suppose the related question is, what does the jurisprudence afterwards say? How is it being applied? How is it being interpreted in the courts?
That is very interesting. You will find that in a lot of instances, especially when it comes to data protection, these matters have not yet gone to court. Either it is an act. In the case of South Africa, it's a 2013 act that only came into effect in 2020. So we don't know as yet. Uganda, it's a 2019 act. It's been there for a year. We don't have a case yet. Do people even know that you can approach the relevant regulator to file a complaint? And if you do, will the regulator take this matter forward? Will they issue a warning? What then happens? We really don't know what the application is, because it seems as though no one is taking up any further. Maybe some of the researchers here would love to just take one instance further for the sake of research.
Right. There was someone asked a question. There's a question in chat from Koliwe at APC.
Yes, we're looking at it now.
One of the critics.
That is definitely one of the strongest criticisms, and I do look at it in the paper that you are finding that some of the data protection laws in Africa are conflating cybersecurity and data protection. I would respectfully like to argue that the problem started with the African Union when they drafted the data protection framework under both cybersecurity and data protection. So if you are asking your member states to use this as a reference point for drafting, naturally your member states are going to draft in that way as well. But purely because the two are different, they should not be housed together. And secondly, Koliwe, on that question, Zimbabwe's bill also has another issue, that you find that the Cybersecurity Regulatory Authority as well as the Data Protection Regulatory Authority will be housed under the Telecommunications Regulatory Authority. So now you have three different issues that are being regulated essentially by one regulator. Where is the independence in that? I also look at that in the paper as well.
I think there's another problem in there. If I look in the UK, the Cybersecurity Agency is effectively a branch of our General Communications Headquarters, our spies. Mm-hmm. The rationale being that they have some knowledge about how to protect our information systems, presumably because they attack other people. And that's a very interesting dynamic, that if you want to secure your system, you may need people with some very interesting backgrounds. The guys in Uganda who are spying on Bobby Wine might be helpful to protect the systems.
That is true, and it is maybe a lack of understanding or intentional, as you've said, but you would not want to have an authority that is supposed to be protecting essentially the right to privacy also being put under the authority of someone who's tasked with managing national security. These entities have to be independent of each other. I would also argue that funding would also have to be separate. Purely because you want people that are meant to be protecting human rights, because data protection is a human right. The reason why I don't want my WhatsApps out there is because they're personal to me. These are personal messages. So you don't want that being surveilled by the state. You don't want that being surveilled by your employer or anybody else. So why should we house the individual that is tasked with protecting that right under, let's say, a telecommunications or cybersecurity or national security authority, or the prime minister in other countries?
Yeah. And then we need to somehow get this to court and get somebody who can tell the government, no, you're going too far. I mean, in the UK case,
it won't happen.
Well, in the UK case, that's usually the European Court of Human Rights, who tell the UK government that they are being very naughty and mass collecting data or doing surveillance. And that's where the behind the Budapest Convention lies, the European Convention on Human Rights, and that's enforceable.
Yes, true. And I think it also comes back to what Francis and Beatrice are writing about in their paper, that firstly, are there individuals, do individuals actually care about their right? Do they understand what their right to data protection means? Can they take it up with somebody else? If they can take it up with somebody else, do we have a court that is going to maybe deal with these matters if the regulator cannot, because they're not independent? I feel like there's so many issues that are in one issue. It's always hard to put in a 15-minute slide or a paper, but yeah, it will definitely be interesting to read this book, because I feel all the presenters that have been presenting throughout this week deal with all the issues, as the issues are not independent of each other. They are very interlinked.
Yeah, that was great. I think we have now run out of time.
Thank you.
Thank you very much, Amanda. And we should now pass to Sizwe. So we're now going from someone who's doing academic research to someone who's much more heavily involved in the state. Sizwe is an advocate in South Africa, but heavily involved in various government activities, and is also studying for his law doctorate. I always think of LLD as honorary. I think that you're the first person I've met who's actually doing it as a degree. So, over to you, Sizwe. We can see your slides. Can we hear you?
Thank you, Prof. Prof. Sutherland. Thank you for everyone for participating in this session. I must just apologize. I was in one or two meetings at the regulator, hence I'm only joining this important session now. But with that having been said, let me not speak too much. My topic today is cybersecurity, cybercrime, and the protection of personal information in the fourth industrial revolution in Africa, with specific reference to South Africa. Maybe just a disclaimer as well. This work is sourced out of a PhD work that is currently being researched. So this paper basically wants to discuss the intersection and the importance of cybersecurity as well as cybercrime and data protection. And the fact that within the fourth industrial revolution that we are in now, it is the time where it has become so clear and evident that we cannot separate these three legal concepts. Up until a couple of years ago, people used to associate cybersecurity with ICT technological issues, but in the last 20 to 30 years, it has become quite clear, both internationally as well as on the African continent, that cybersecurity, as much as it is based on principles that are technical, that we have now brought in these technical principles into our legislation. I will briefly have a look at the African Union Convention as well on data protection and cybersecurity. You will recall Prof. Sutherland had a critique on that in a previous paper that he presented. But just to bring us closer to Fourth IR, what exactly is Fourth IR? I'm one of those people who really likes to deal with concepts, you know. What was the first revolution? Well, the first revolution was your steam. It was your railroads. It was your trains. Then your second revolution, your industrial revolution, was that of electricity. Using electricity and having that make things easier for us. Then the third revolution came, and that was the moving from analog to digital. I like to sum it up like that, because analog was based on electricity, it was based on signals. Digital is still based on signals, but we have now encoded digital signals in analog signals. And the fourth industrial revolution, where we are now, is the one where we say we've gone entirely digital. We're using the digital information that we get to make our lives easier. We are even going to the realm of artificial intelligence, as well as using big data to develop certain things and also to analyze certain information that one wants to do. So, like I said, big data, once again, is a big issue. One may argue that, but big data doesn't necessarily contain personal information. It rather more contains information about information. But there's clearly a thin line between what is personal information and what would be personal information within the realm of big data. So one needs to be very, very cautious about that distinction. Now, for one to have this discussion about the fourth industrial revolution without looking at this unique interplay between cybercrime, cybersecurity, and data protection would just be irresponsible for anyone in 2020. I mean, if we look at the antecedents of our cybercrime laws, they're all based on what we call the old Budapest Convention. I mean, it's been around for a while now. South Africa has signed same. And if you look at our ECT Act, I think you can see a lot of resemblance between the substantive law provisions contained therein and what is in our ECT Act. I'll be discussing our cybercrime bill shortly, which will also be giving more effect to the subsequent protocols of the Budapest Convention. A lot of people think that the Budapest Convention is the Bible and it ends there. There are a lot of subsequent protocols that the Council of Europe has had to investigate pertaining to cybercriminality and how cybercriminality impacts on other aspects of the law. Like I said, on an African regional basis, we have the AU with its efforts trying to codify cybersecurity and data protection. We also have efforts in the SADC regions, as well as the ECOWAS, as well as the East African community. I think at this particular platform, it would be a little bit too extensive to go into all of the provisions of what the ECOWAS says and what the EAC says, but it's very important to say that the African Convention of Cybersecurity places a duty upon African states to recognize what we call processing of personal data. And that in itself is extremely important because it now creates legitimacy to say that within the African legal context, data protection is not just something that we hide within privacy itself, but it is actually a subset of the right to privacy. And the right to privacy, as we know, is not contained in our African Human Rights Charter. But with that having been said, there are now subsequent documents of the AU that have extensively dealt with the right to data protection and so forth. And that specific right also is entrenched in our constitution, and as you would find it in our POPIA. So the African Convention also deals with several aspects of cybersecurity. You will notice that the focus on the African Convention, if one looks at it really properly, the focus is more on e-commerce, cybersecurity, and cybercriminality. But I'm pleased to say that at least there is some reference to data protection and the fact that data protection has to be there, and that there needs to be a competent data protection authority to deal with breaches of personal information or misuse of personal information. Now, I don't want to preach to the converted, because I am speaking to the converted, but we all know that on the 1st of July, the grace period entered in South Africa regarding POPIA. So it is the period for people to get compliant. I always say to people that the grace period is not there for you to not comply. It is there for you to get your house in order so that when the grace period does end, similar to what we would call a sunset clause, when the grace period ends, you need to have your house in order, because at that time when the law is fully in action, there will be consequences for the misuse of personal information. Now, on the other hand, you know, I always get the question of, what do we do in terms of cybersecurity breaches? Are they criminal aspects? Are they data protection aspects? So for a very, very long time, cybersecurity breaches were dealt with within the realm of the ECT Act. The ECT Act has been with us now for more than 20 years, and it really sets out in Chapter 9 all the sanctions in terms of sections 85, 86, 87, 88, 89 of the ECT Act. But there has never really been any consequences for either the negligence of those who are keeping the personal information, or for those who intentionally went out and caused breaches at the respective places. So once again, we all know the 8 conditions in the POPIA. I don't want to preach to the converted, but for the purposes of this discussion, sections 19 and 22 become of paramount importance, because that is where we have the intersection. You will notice that our Constitutional Court, in the case of Black Sash, Trusts and others versus the Minister of Social Development and others, the court really paid an emphasis about the adequate safeguarding of personal data of grant beneficiaries. So this issue of safeguarding of personal information has now not just become an ICT issue anymore, but there is a positive duty in our law. If you process personal information, if you make it your business to keep and store personal information, then there is now a positive duty upon you to have adequate safety guards as to how you protect this information. So just going back to condition number 7, right? And you will see that from sections 19 to 22, there is the whole issue of reasonable technical and organizational measures that one needs to put in place. I always say to my students that the reasonable technical measures is your ICT measures, your software and your hardware, and the organizational measures, that is you and I. That is you and I, that is your subordinates, that is even the lowest of lowest person in the hierarchy of the company. Even the cleaner that comes to clean your office can be a possible risk, because if from an organizational point of view, you don't have measures, for instance, that you are going to shred documents once they are finished, once you're done using them, or you are only going to have one file on your desk at a time, for instance, like at a law firm. I always have a lot of arguments with my candidate attorneys to say, you cannot possibly have 5 files of different people on your desk. That in itself, from an organizational point of view, would be a risk in terms of safeguarding your personal information. And Section 9.2 goes a step further to assist persons with risk identification, coming up with appropriate safeguards, as well as effectively implementing these strategies relating to technical and organizational safety guards. We've learned now, from what we've seen in the media context, and please, a disclaimer, I'm not speaking on behalf of the regulator here, I'm speaking as myself, hence I'm making reference in the paper to newspaper articles regarding to the breaches. I'm unfortunately bound to confidentiality. If you look at POPIA, it says anyone who works at the Office of the Regulator is bound to confidentiality. So the breaches that I refer you to are breaches that are in the public domain, where there have been public statements either by the responsible party, such as the Experian one, the View Finds one, and the famous data breach, which they said happened at the Deeds Office as well. Very important in terms of Section 22 is the reporting feature. Not only now do you have a right to have your personal information protected, and a positive duty is imposed on a person who processes personal information, but should you be negligent, should you, during the course of processing this information, and remember processing is broadly defined, the storing also includes processing, then you would have to self-report to the Office of the Regulator within a reasonable time, taking into considerations the needs of law enforcement, of course, as well as to the data subject. Why do we report to the data subject? Well, we report to the data subject so that the data subject becomes aware, so that the data subject can take measures against suspicious activity on the bank account. It is for that reason that the self-reporting measure, not just to the amount, importance. Then, like I said, it's not just about data protection either now. So our legislation has really, really evolved. On the one hand, we had the ECT Act, where data protection principles were not mandatory. Thank you, Prof. Were not mandatory. These principles now have been brought into the POPIA, and they are now mandatory. And we now see a very positive step since 2015, the drafting of the Cybercrimes Bill, which has now become the Cybercrimes Bill of 2018. You will note on the slide that the provisions relating to cybersecurity have been moved. They were initially in the bill, but you will now see bits and pieces of it in the Critical Infrastructure Protection Act, and hopefully another piece of legislation relating to cybersecurity. So just last but not least, I'll just have two more slides. You will also note in the POPIA, unlike in the ECT, in the ECT, the sending of spam, if you had opted, see anyone who was sent to jail for that. And I think it is for that 9 of the POPIA, where a transgression of spam or what do you call it, unsolicited electronic communication would be deemed as a transgression of POPIA and a breach of personal information. I'd like to speak longer, but I think I've said enough. Thank you very much, Prof. Sutherland.
Thank you very much. Contact your lecturer. I like that. Right. Are there any questions? All that complicated explanation of the legislation. Now I see no questions. Can I ask a question?
Yes, Prof.
You frame this in terms of the Fourth Industrial Revolution. You know my views on Fourth Industrial Revolution, so we'll ignore that for a moment. Is the pace of the development and the implementation of the legislation, is it revolutionary? Is it keeping up with the sorts of developments we're going to see?
Yes, I think in South Africa and in Africa generally, and this is one of the antecedents of colonialism, unfortunately, or the consequences thereof, is that we'll always get things on the back end. I mean, if you look at the GDPR, it's been implemented in Europe now, and it's been redrafted from the previous directives. In fact, it has had impetus since the early 1980s. So in terms of that, I think our legislatures and our drafters of African legislation have been a little bit slow in keeping up with international trends. But I think it is the fourth industrial revolution in itself. In other words, the use of technology, the use of data, and the way in which we use data that has forced legislators to get with the program. In other words, what I'm trying to say here is I myself am not a fan of fourth industrial revolution itself. I believe that it is one of those terms that has been used and abused by politicians and they don't even know what it means properly. But with that having been said, I think in this paper, we are trying to say that the advent of the fourth industrial revolution has created a wake-up call for African legislators to say that GDPR is not a European thing. The Safe Harbor Agreement is not an American thing. We are in Africa. We are using the internet. We are using our devices. We are now using Zoom. There have to be proper safeguards to protect our personal information as well as cybersecurity in us using these devices. So I think, Prof, that is the convergence of what I was trying to bring across in this paper, Prof. Thank you.
As someone who used to live in Brussels and used to deal with this stuff all the time, you point to one of the things which has made the European Union reasonably successful in this area, which is its ability to legislate, implement, review, re-legislate, and go through that cycle, which in technology areas seems important. Is that going to happen?
I think COVID-19, and I don't want to abuse COVID-19 because that's another abused thing, but I think COVID-19 has been a wake-up call, though, to say that, you know, we have to use technology now in the way in which we do business. I mean, the other day I went home and I had to assist my mother, who lived in Europe for many years, to connect a Zoom call, and she didn't understand what a Zoom call was. The other day I had to assist my father, who's a retired professor, to get on an MS Teams thing to attend a conference. You know, so it's really become part of our life. We cannot ignore the importance of cybersecurity, data protection, and how it affects our lives. And I think, like I said, Africa has had a very, very serious wake-up call here in terms of lagging behind. And I'm actually one of those people who is in favor for a African data protection norm and principle. I think once we have reached that level of appreciation for that, then I think it will not be a foreign concept anymore. It will be part and parcel of our lives. Thank you, Prof.
In the chat box, you will see a question from Emmanuel, which was asking about that point, which is asking whether with cybersecurity, cybercrime, and personal data all interrelated, should they be regulated as one?
Thank you for that question, Emmanuel. When this question comes from my university students, I always say, much as they are not brother and sister, they are, however, cousins, because they have a common ancestor called vulnerability. And because they have this common ancestor called vulnerability, however, the issues that they protect are separate. For instance, for a very, very long time, people used to synonymously use cybersecurity with cybercriminality, and that is completely incorrect. Cybersecurity is an advanced level of protecting ICT infrastructure as we know it in these days. Cybercriminality is the substantive law, in other words, the do's and the don'ts, as well as the procedural law as to how to collect evidence, how to produce evidence in court. And then personal information now is the new legal conundrum, in terms of which the regulator will be ensuring and protecting and regulating the use of personal information. That is not necessarily criminal, but is a nuisance and maybe an invasion of your privacy. I hope I've tried to answer Emmanuel on that one. I see Mr. Gumede from my office has also made a comment. What is he saying? I agree with the notion as a wake-up call. Okay, it's just a comment. Okay, over back to you, Prof.
Are there any more questions? Can I take you back to the question of the African Union Convention? Does it really matter? In terms of, well, let's think of the Budapest Convention. Part of the Budapest Convention is if there's a crime being committed across a border, you can get access to the data, you can seize data, you can do all sorts of things. If you're sitting in South Africa, where do you need the links to be to? Which countries do you want the treaty with? Do you want the treaty with Uganda and Kenya, or do you want it with the US and China?
That's actually a very interesting one. At the time when I was doing a lot of research on cyber criminality and cybersecurity, I'm aware that the UN and organizations such as NATO have actually been trying to come up with what one could call an international convention on cybersecurity and cyber criminality. But I think because of political issues, I mean, I'm not a politician, I'm a jurist, but I think because of political issues, we are very, very far away from having an international cybersecurity convention. And it's not because we don't have competent jurists. I'm sure we have very competent jurists within a whole lot of jurisdictions to come up with a convention. But I mean, it's an international phenomenon. And it would be silly to say you only want an agreement with a particular country. Ideally, like I said, it would be nice, similar to other regions. If you go to South America, they have their own thing going on there. If you go to Europe, they have their own thing going on. Even the Middle East, as much as they have given in to European data protection principles, they have designed their own data protection principles within their constitutionalism, within their boni mores, within their convictions of law. So I think, and I'm going back to that to say, an African norm, an African data protection principle / cybersecurity principle is not something that is bad. It is something that we need. We do need cooperation. The convention may, however, be a little bit old. I'm actually one of those people who was criticizing the convention, but for the purposes of this paper, I couldn't talk well about it and crush it in the same one. So it is a little bit old. I actually know the drafters of the convention personally, and I know why it came so late, because the whole of Africa was really behind. So the drafters of the convention were really trying to fully integrate these norms and these rules on an African level. So I think the convention is not to be thrown away, but I think it is to be relooked, it is to be revised, and to be given more legal force and more strength than what it has already had.
Right. I see more comments and questions in chat. Capacity building from Roosevelt, who is in, I can't now remember which country.
Yes, I see Roosevelt, yes, JJ. You know what, it's actually interesting that you're asking me this question. Before I ventured into data protection, which is my greater part of my life now for the last 4 years, I used to zigzag the African continent doing just that, building capacity on cybersecurity issues and cyber criminality, training judges, training prosecutors, training police. I mean, I did work with the ISS at the time. and several regulators across Africa really would invite me to come and do 2-3 day training sessions on cybercrime and cybersecurity. So I think what we would call the 419 scams, you know, we always use 419 synonymously with cyber criminality. If we only knew that section 419 actually has something completely else to do in the criminal code in Nigeria. But I think African states have now reached the stage where we are aware that there is cyber criminality and that we need to train our police, our prosecutors, our lawyers, and especially those who are dispensing of the law. So I'm not saying that we have sufficiently reached a point where I can say Africa has reached capacity, but I think the efforts have been good. The international community has been very assisting as well. Organizations like the Council of Europe investing monies into training of judges and so. So I think we are on the right path, but we just need to improve it. I mean, I was one of the people when they were looking at revising the LLB for South Africa, I was one of the people who insisted that cyber law, which is my forte, that needs to be a compulsory subject at the university. You cannot have a legal practitioner in 2020 graduate from university without cyber law. If you look at the New York Bar Association, it is unprofessional conduct not to be afraid with technology. So I think that is the type of mindset that one should have with regards to technology, cybersecurity, data protection, and all of these things. So yeah, we're not there yet, but we are coming along. That is how I think that is my most diplomatic answer that I can give to that question.
And I think the related question which came up from somebody else, which was to do with civil society, and there's a fair bit of capacity development needed there. Though you're commenting on the US, I think the US bar associations have finally been persuaded they don't need in-person examination because of COVID.
Yes, I mean, myself, I'm an examiner at the LPC, and I'm proud to say that over the last 5 years, you know, we've really tried to shape even the practical legal training. Once again, cyber law there now is a course. It is an integral part of a practitioner. You know, I mean, if a client walks into your office and says, my personal information has been stolen, as a legal practitioner, you should know that this needs to be reported to the regulator. If you have an issue regarding an electronic contract, your mind should tell you immediately, I need to look at the ECT Act. So that is my view. It's a very controversial view. I know there's some people who don't agree with me on this, who still think they want to hide behind their typewriters and so, but since we are hiding behind our laptops of late, I think the issues of data protection, cybersecurity, and cyber law as a legal subject really need to be taken seriously. Thank you very much, Prof.
And do you reckon anybody in the South African Police Service is doing this?
I'm not sure if there are any members of the South African Police Services here today. I wouldn't be surprised if there are. My experience is that we have a relatively advanced cybercrime lab with very competent people. However, I think it's a capacity issue. Most of these labs are in your metropolitan areas. So yes, you are most likely going to get joy from reporting a cybercrime incident in the big metros. But what about that person whose money gets ripped off, who's staying in some village, who's not even using a 3G connection, but old school GPRS, because we still have people who connect using GPRS. So I think on that perspective, I think our South African police need to really invest more money into the training of their own staff to educate them how to take a cybercrime case. I mean, in most instances, we have to literally do the affidavit for the people because we have to refer to the relevant sections and so forth. A little bit of CPD training, 2-3 days, educating the police wouldn't hurt. So I think from that perspective, I think education is paramount. And now even with data protection, I mean, I did a stakeholder engagement not too long ago. There's a misunderstanding that POPIA does not apply to law enforcement. And that is a wrong fallacy. It says information that is processed during the course of a criminal investigation, that may not be subject to POPIA. But the police service itself, they themselves, their records, their processing of personal information still has to comply with POPIA. And in the event where they have a breach, they must still self-report. In the event where they abuse personal information, they may be subject to a fine as well.
Yeah. That's great. If there are no more questions, I can thank you, Suswe. I can thank Amanda. I can thank Thompson, Francis, Beatrice for very useful, very informative morning. And I guess someone's going to come in and tell us we come back after lunch. Yes.
I'm here. Thank you very much, Prof, for taking us through, for shepherding this process. I'm going to thank Professor Iwan for facilitating this session. Thank you very much for your time. Our presenters, Sizwe Snell-Gamtuze, thank you very much. From a busy schedule, you managed to join us. Thank you very much, Amanda Manyame, for your insightful presentation. Thank you so much, Dr. Thompson Chengeta, for the interesting presentation on autonomous system weapons. Yeah, thank you also to Francis and Beatrice for the opening presentation on national security issues and data protection, and giving us the perspective from Kenya. At 2 p.m. South African time, we'll be starting the session on privacy, data protection, and artificial intelligence. Things are getting really interesting, so please do join us at 2 p.m. South African time. We will have Dr. Thompson Chengeta as the facilitator. As for the Zoom details, we are using the same details that you just used to log on to this particular session. Thank you very much. Enjoy your lunch, wherever, if it's lunchtime where you are. Thank you. Yeah, gosh.
experience increasing export by
Yeah. 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 Yeah.
Dr. Chengeta, are you there?
Hello, hi, how are you?
Fine, thank you. Just checking if we have all our presenters. Professor Moritz?
Yes, hello.
For some reason, I'm not seeing anyone.
Okay, Professor Moritz is there. Wakesho?
Yes, I'm here. Wakesha is here.
Thank you. Emmanuel will be joining us later. Yes, thank you, Wakesho. And Wanjiru?
Yes, I'm here too.
Thank you. Alan?
Yes, I'm present. Thank you. Can you hear me?
Yes, thank you, Alan.
Okay, great.
So, Dr. Chengeta, Emmanuel will be joining us later. I'll notify you.
Okay.
But otherwise, we have all our speakers, and I think our audio also is okay. We can all hear everyone. It's now 2 o'clock. I think we should be starting. So hi once again, everyone. Hello, welcome to the second session of the day. In this session, we are looking at privacy data protection from the perspective of artificial intelligence. In the morning, we were looking at cybersecurity issues, national security issues, and we had great presentations. And we are also hoping that this session is going to be an equally interesting one. We will have 4 presentations, and I'm going to hand over to Dr. Thompson Chengeta to facilitate this session. Dr. Chengeta, over to you.
Thank you very much, Tlengiwe. Good afternoon, or good morning, or good evening to everyone, depending where you are joining us from. I want to welcome you to this session on privacy, data protection, and artificial intelligence, where we actually have a group of very interesting presenters looking at various issues on artificial intelligence, the ascent of artificial intelligence in Africa, regulation of artificial intelligence, and the relationship thereof to data protection. I must say that maybe just like everyone else who may be tuning in right now, I'll be also equally interested to be hearing from the presenters on these various topics, for example, starting with their also understanding of what is artificial intelligence. Do we perhaps understand this term to mean the same thing? You know, what our panelists today's understanding of the term and how they're applying it to their researches. And we'll also be hearing also topics to do with algorithmic decision-making processes and profiling, issues of liberty, and also the issue of safeguarding privacy in governing artificial intelligence in Africa. Without wasting much time, I would want to invite the first speaker, Professor Moritz Hennemann. Please do forgive me if I'm not pronouncing your name correctly, who's going to be presenting on the issue of African data protection laws and artificial intelligence regulation, innovation, and instruments. By way of introduction, Professor Moritz Hennemann is a full university professor, chair of European and International Information and Data Law, and is the director of the Research Center for Law and Digitalization at the Law Faculty at the University of Passau in Germany. And between 2016 and 2020, Professor Moritz was a postdoc and a faculty fellow at the Institute for Media and Information Law at the University of Freiburg in Germany. And in 2018, he was also a visiting researcher at Harvard Law School, and he has been actually been visiting and been a visiting professor at a number of institutions, which you can be able to access on his profile. Without wasting much time, I cede at this moment the floor to Professor Merits. Welcome. Professor Moritz, are you there?
Yes, thank you so much for your kind introduction, and thank you so much for this invitation to this conference. That's a great honor to speak and to add an EU perspective to this conference maybe. Obviously, artificial intelligence and African data protection laws, that's a very big topic, a very broad topic, and I try to give a general overview from my point of view, which is obviously an outsider's perspective from the sideline and perspective that might be limited. When I talk about AI, I do refer to adaptable algorithms, so algorithms which are based on principles of machine learning, based on neural networks, are self-learning and are therefore adaptable and not programmed in any aspect in advanced. So regarding the current stand, I would like to highlight, first of all, that obviously AI is used in so many different scenarios. It's used in state-citizen scenarios, in state-state scenarios, and citizen-citizens scenarios. And obviously, we would have to look at all these different scenarios independently. As a general aspect, obviously, AI is based on data processing. And the idea is that from processing data, new patterns, and on that basis, new insights, new knowledge can be extracted from the analysis of these data, and patterns can be identified that have not been seen before. And on this basis, obviously, AI and the usage of AI on a very theoretical level is a little bit at odds with the basic principles of data protection law, especially the principle of purpose limitation and data minimization. So my team and I looked at a couple of countries or a couple of African states regarding the question to what extent AI is covered by data protection regulation. And to say it clearly, obviously, artificial intelligence is done on the basis of data processing, and data processing in itself is obviously regulated in many of the African states. You know that better than I do. So AI and the usage of AI is generally obviously covered by the general rules on data processing. Nevertheless, at least we, and this might be a limited view, we have not found any specific artificial intelligence regulation within the data protection laws. And please correct me if I'm wrong on the field. So no specific regulation on the usage on AI on the basis on the definition I just gave. We see, however, obviously different initiatives within Africa and within specific states. So, for example, on the strategic level, Kenya has engaged in different ways with the usage of AI and has published a report of the Distributed Ledgers Technology and Artificial Intelligence Task Force with regard to AI. We have seen initiatives, an AI task force in Tunisia, which is developing a strategy, and we have especially seen an AI strategy of Mauritius, pointing to the usage, for example, of regulatory sandboxes for AI in order to, inter alia, evaluate adjustments to current legislation, as well as the possibility to establish an AI council to monitor deployments and develop new legislation, a standing AI committee on ethics and governmental data centers. And we have seen, for example, in South Africa, a presidential commission on the fourth industrial revolution, obviously also dealing with this point, as well as Ghana is, for example, which is very active as far as I can see it with regard to data protection regulation. So in general terms, we do see a lot of data protection regulation all over the African states. And we have seen within this conference that most and on nearly all of the data protection laws we see are in some way or the other inspired by the European Data Protection Directive and the European, obviously, General Data Protection Regulation. And the fact that we do not see specific rules on artificial intelligence there might be also worth noting. Then if we look, and this is obviously my home turf, to the EU and the GDPR, we do see that we do not find a specific artificial intelligence rule within the General Data Protection Regulation. We do find a rule on automated individual decision-making, including profile, as we do find similar rules in various different African data protection laws, which do have a rule, obviously, on automated decision-making. And this rule does cover some aspects of AI with regard to a specific decision making, but it does not actually cover specifically the ways of data is processed in advance, or it does not give specific leeway with regard to AI. And we, as a second aspect, obviously find some rules within the information duties within the GDPR, so in Article 13 and 14, which do establish that someone has to inform about at least the logic behind an automatic decision-making, which does a little bit, at least, also lead to an explanation with regard to AI. So what we have to notice, however, is that the GDPR, which is seen as a blueprint worldwide, is, at least from my perspective, and obviously this is debated, the GDPR has not solved all the problems we have, or you could say it's not without doubt whether the GDPR is actually an instrument which really triggers information and tackles the risks associated with data processing for individuals in a proper way in any respect, especially as the GDPR is pretty much mirroring the old German approach of data protection law and a state citizen perspective, which might not suit the citizen or private to private interactions in every way. And as obviously AI has developed rapidly within the last years, within the European Union, thoughts have started and papers have been written on the European Commission level that one might actually reconsider the framework also with regard to AI and to adjust maybe regulation. And this might, it's not clear, might also lead to a modification of the data protection rules. We don't know yet. However, what we have to notice is that the GDPR is also from an economic perspective, not without doubt, whether the GDPR does actually find from an economic point of view the right balance between innovation and burden and compliance cost for companies or the private sector. And in general, obviously, the EU is pretty much based in in the European legal tradition and legal values, and might on that basis not always be suitable to be implemented elsewhere. So on this basis and within this short time frame of 50 minutes, I would like to point to the fact that I personally think that the GDPR or the data protection regulation and copies thereof should be reconsidered, whether one could not actually come up with a unique new approach balancing the interest in another way. And this might be done if someone does consider elements of group privacy, which are, as far as I understand it, are also discussed very broadly within the African contracts for good reasons. And one might also think of the question whether it's actually a good thing that the GDPR is a one-size-fits-all regulation, which is applicable for every data processing in every sector. Maybe one should, at least for AI regulation, consider a risk-based approach, and that would also mean for data protection rules on AI that those rules might only limit data processing if a specific risk or within a specific sector is at stake. And one should also obviously see artificial intelligence from another viewpoint, especially as it might help actually to boost privacy by the usage of AI in the form of privacy bots by individuals at some point, which might be a standard feature, or we might see that as a standard feature in the future in order to enhance private information management systems for individuals to the benefit of their own privacy. And as a very broad, and this is only a rough idea, obviously, at least from my perspective, one might consider to bundle the idea of the data protection regulation with regard to AI, maybe in a sort of model law on regional or African Union level, or obviously on national level. So these are my broad thoughts I wanted to share with you, and I'm very honored to do that in this conference. And from there on, I do thank you very much for your attention and the possibility to be at this conference. Thank you very much indeed.
Thank you very much, Prof. Moritz, for a very interesting presentation. And at this moment, I would want to invite anyone who may be having questions. If you may please do ask those questions, or if you can type them. If not, please just tell me and I'll be able to give you the floor. In the meanwhile, while some of you may be thinking, I just wanted to sort of pass a comment, which perhaps Professor Moritz, you may be able to react to based on your presentation. You particularly mentioned at the beginning of your presentation that there is perhaps no specific AI regulation in Africa. And then towards your conclusion, you ask whether one should consider a risk-based approach to AI regulation in general, and also if one should consider if there should be a regional level model of regulation when we are approaching this. My current view on this aspect, particularly referring to artificial intelligence technologies, which perhaps come in to some extent as a concern, is that most of what perhaps may be referred to as artificial intelligence technologies on the African continent have their origins, if I may say, from the Western world. I'm not sure to what extent there's been adaptation of the same AI technologies, to fit, for example, the context of Africa, particularly the needs of Africa. So now I could give an example that, you know, within the Western world, for example, in this digital age where there are problems such as, you know, online hate, they are currently developing, using data sets from the Western world, how to respond to such kinds of problems through artificial intelligence technologies, which can detect automatically or autonomously hate online, for example, and respond accordingly. But if you see the data sets that are being used, particularly if you look at the Alan Turing Institute in the United Kingdom, they are, of course, using data sets which are relevant to the Western world. And so when some such technologies start finding their way to the African continent, I'm not sure to what extent those AI technologies are actually being adapted to fit the context of Africa. Now, that in itself, I feel as if then it affects how you seek to regulate those particular technologies, because if they are not originating to begin with within the African context, or they are not alive to the issues on the African continent, so to say, your regulation, I'll assume that will be different. So perhaps I wondered if you may think that perhaps the absence of specific AI regulations on the African continent may be, you know, caused perhaps by the fact that most of such technologies actually are not founded on the African continent to begin with.
Thank you very much indeed for your question. And I'm not an expert on AI economy, but to have rules and specific rules on artificial intelligence, which do give an innovative framework, an innovative regulatory framework, is obviously one aspect which might indeed attract companies to invest in AI, to give them legal certainty with regard to their applications. And on this basis, indeed, I would agree with you that specific rules which do guarantee such boundaries for respective economic activities might be one of the possibilities to boost AI and the AI economy in any state. Thank you very much.
Thank you very much for that comment. Maybe just as another follow-up, I'm not sure if maybe you've looked on this. With the comparison which you make, particularly on attempts to regulate, you know, artificial intelligence in Europe, in America, and other regions, if Africa is to get some lessons there, usually, in my view, or from a legal point of view, you know, a good regulation needs participation of citizens, particularly citizens of a particular country. So, for example, many laws which you mentioned on Africa regarding data protection, for example, recently in Zimbabwe, you would find that there is some sort of participation from citizens where the legislator passes or drafts a bill and then asks the citizens to participate on those particular issues. Now, I wonder if you may have an idea how someone could perhaps try to overcome this problem or the challenge which I'm going to mention in a minute. When you're talking of artificial intelligence regulation, if citizens were to participate in the regulation of artificial intelligence, surely the same citizens should be able to be understanding what artificial intelligence is to begin with and the issues that comes with artificial intelligence. And the problem that also currently exists is that the language that is used, coding, the language that is used when you're talking of artificial intelligence, the same terminologies may not be found, for example, in local languages, many local languages in Africa. So the challenge then becomes, how do you begin to go to those communities and talk about artificial intelligence, a term which even if you try to find it in local language terms, does not yet perhaps exist. How do you then make citizens participate or be aware of these issues with these issues of language limitation, beginning with, because this technology, as I mentioned before, is not necessarily originating from Africa? Professor Moritz, I think you have to unmute yourself.
Thank you so much for your additional questions. And I would be extremely happy if I could solve, for example, the language question you rightly pointed to. And this obviously is part of the broader context, which you also mentioned before, that we see data biases within the data set, which are based on limited data collection, which then mirrors respective decisions, maybe to the detriment of those then actually using these applications. But I'm absolutely with you that this is the way to go, that we should actually boost awareness for artificial intelligence and take the burden of collecting data sensibly and using hopefully every language that is applicable, although this is obviously a big burden. However, and this links to your other point, understandable AI and understandable mechanisms and understandable regulation does go along with acceptance by communities, by the population. So this again obviously underlines the aspect that regulation might not be something just imported from somewhere, or not only the GDPR or the directive, but unique approaches that do actually mirror the local values and local traditions, as probably only this kind of regulation might be then accepted, and in that sense, then good and sensible regulation. Thank you.
Once again, thank you very much, Professor Moritz, for those interesting responses and interesting presentation. With that, for any other participants, if you have any other questions, please feel free to continue sending them on the chat box. I would want to move to perhaps the second presentation by Wakesho Kililo and Wanjiru Muya. Again, if I'm not pronouncing your name correctly, please do forgive me. Briefly, Muya is a lawyer and a police researcher who is passionate about data governance and digital rights, and she holds a law degree from the University of Nairobi and certificates in digital identity and IP law from the Digital Frontiers Institute, South Africa, World Intellectual Property Organization, and the Korean Intellectual Property Office. She currently works as a tech policy fellow at the Lawyers Hub in Kenya, where she undertakes research and publishes reports on identity and digital, reports on tech policy in internet governance, digital trade, digital identity, and digital inclusion. She has drafted submission on the Data Protection Bill in 2019 to the National Assembly ICT Committee, shaping the procedure of appointing the Data Protection Commissioner. And she's coming with Wakesho Kililo, who is the founder of the Future Practice, which is an initiative that is at the forefront of inspiring and aspiring young lawyers to design innovative solutions to pressing social needs and challenges. And she also currently serves as the program manager of digital identity at the Center for African Affairs Conflict Research. And she has worked with a number of organizations in Kenya and in Africa. And particularly, I would also mention that she works with FIDA in Kenya, the Civil Society Law, and also the International Commission for Jurists. I would like to welcome these wonderful presenters to please take the floor.
So thank you. I hope I'm visible and audible. So my name is Wanjiru Muya, and I'll answer the first question, which was to say what AI means to us and our presentation. And so I'll pick it up from where you left in terms of saying that across the African continent, yes, AI is used for development, and that is what the previous speaker just mentioned in terms of using AI and having governments commission AI blockchain reports like in Kenya and in Uganda on how to use this development. But then the use case for the actual use case for them, like business use case, is still limited in terms of how those reports actually reported them, in terms of using AI for land tilting, conveyancing, and dealing with corruption, for example. But then just to say that the use of it in private practice is actually limited. So in 2019, Google actually held an AI competition, and out of 20 solutions that were selected from all over the world, only one from Uganda actually made it. So, but in regards to this paper, and with regards to us, AI for us actually means how we interact with it as normal day Kenyans and Africans, and that's with AI used in search engines, AI used in recommendation systems, AI used in filter bubbles, AI used in automated decision-making, and then now in automated technologies. So that's what AI means for us and the focus of our paper. So there is, okay, so because of the topic that we have, which is to lay out the data protection framework in Africa, we thought we'd give you a resource and this map that would be a guideful resource. And so the source is Data Protection at Africa, that actually just gives the levels, the actual countries that have data protection legislation and where they are at. And the focus, I'm trying to take as little time as possible, so I hope you hear me. But with regards to the legislation that we actually have, we have, across East Africa, we only have 2 countries that have gone on to implement data protection frameworks, comprehensive data protection frameworks that actually deal with the following things. So for example, if it's definition of sensitive data or collection and processing of data or registration and enforcement. However, even though we have this legislations, the enforcement of these legislations is what is now seeming a challenge. And so yesterday, as recent as yesterday in Kenya, the president appointed the Data Protection Commissioner, which is supposed to be confirmed by Parliament. But the challenge that we're having is out of all the shortlisted candidates, which are about 8 candidates, he picked one who was a previous commissioner for the Independent and Electoral Boundaries Commission. That's the commission that's responsible for carrying out national elections. Now, the challenge is in the previous election, the elections were nullified because of issues to do with data handling and data processing and transparency requests. And so we don't feel that she was appropriately the correct candidate, but we still want to see how that plays out. And so these are some of the challenges that we get in actual implementation of data protection legislation. And the implementation has not been very effective. But then our focus of our paper focuses on 3 countries, which is Kenya, Nigeria, and Uganda. And so we've tried to list out how this legislations in terms of the constitution or the national data protection legislation or cybercrime legislation actually protects privacy. Because as a previous speaker mentioned, the AI is regulated by processing because it processes large amount of data sets. And that means the only regulations, the regulations that regulate privacy will also regulate AI. So in terms of what they provide, this is just basically what they provide for. But I really want to point out that in terms of giving this analysis, we left out national security laws and communication regulation laws. Not that we don't think they're important, but we actually do. It's just that for the framework of this presentation, we didn't actually do it, but in our paper, you will find it. So this is just an example of what goes on, but I really just want to comment on what previous discussions were in terms of content moderation in Africa, for example. So as recent as, was it September, the Web Organization released a report where they recognized that content moderation policies are not enforced the same in the global north and the global south, where Africa lies. So you will find that even when it comes to issues of online violence and discrimination against women, the content moderation policies are not enforced the same. Regulation on hate speech is not, so what you have with women and content moderation is that even people who are activists and who are human rights activists who actually are using the platforms as a means of activism oftentimes sometimes have their content irregularly taken down. And so that's one of the challenges, just on what Dr. Thompson was trying to allude to when he says that, the data sets that are used in this in this quote unquote, so the data sets that are used to make this technologies are in themselves don't actually take us African context. And so I think that what solutions we might have is to give us more power in terms of regulating the content that we can see and regulating the content and giving us more power to be able to report content online and having the review of our reports actually more manual than automated. So that is one of my recommendations, because we have seen troubles, like for example, as recently as in Ethiopia, when they were trying to regulate hate speech and online content. And there was an open letter by Access Now calling on these organizations such as Facebook to enforce this content moderation and make this available and make this information available in languages people can understand. So I think there's a knowledge gap in regards to content moderation and knowledge of the public on the need for content moderation, number one. And then number two, the enforcement and data sets of the technologies, which can be made more efficient and can be made to design products that are used for us and by us. And so there's a call for people who are, because of these technologies, to actually just make technologies that are meant for us. But I would like Rakesh to speak at this moment. So yeah.
Thank you very much, Ms. Muya, for sharing the thoughts of our paper up to that point. And the struggle is obviously with the 15 minutes that we have had, and as you can see, we've clearly just had to quickly jump forward so that we at least deliver a lot of the content that we wanted to present today. And so basically, in terms of, again, what we're trying to, what our research is looking at, we're then trying to reconcile, privacy and how, how artificial intelligence interacts with privacy and what sort of regulation there is in Africa. So as she mentioned, our focus has been on Kenya, Uganda, and Nigeria, but then we hope that our recommendations will also transcend those countries and be applied throughout Africa. So just in adding to what my colleague has just presented, again, when we're looking at AI, some of the things that we're noticing is that one that is that AI-driven decision-making systems rely on the collection and exploitation of data, and therefore AI poses great challenges to the notions of consent, transparency, and other data protection standards that are the pillars of data protection. And also you see that AI poses a significant challenge as to how individuals exercise control over their data, as as she was also pointing out and as Professor had pointed out earlier. So basically, again, one other thing that we can draw inference to is that the potential of AI to perpetuate bias and discrimination. So then when we turn and look at legal frameworks and the legal responses to the threat of the deployment of AI and the deployment of AI tools and systems, we are seeing that we have in place in these countries and in some of the countries that we looked at is that we have data protection legislation that contain, or rather that have principles of personal data protection with emphasis on privacy. This other thing that we are seeing is that some of this data protection legislation have, provisions with regard to automated decision making, which is one aspect of AI, and back to how we defined AI. The other thing we are also seeing is that some of this data protection, legislation provide ways for seeking redress in areas where a decision has been taken that is based solely on automated processing. And we see that, the data subject has the right to request, a processor or a controller to reconsider that decision or to take a new decision that is not based solely on automated processing. So those are some of the ways that we see, this legislation trying to address the AI and how it relates to privacy. The other thing also is, again, when we're looking at automated decision making and algorithmic decisions, we know there's also as we mentioned again, the potential of AI to perpetuate bias and discrimination. And we see that at least in the countries that we're looking at, we have non-discrimination enshrined in the law and in their constitutions, so to speak. And that is one way that we are finding comfort in, the protection of privacy and the challenges that AI is bringing to the right to privacy. So just quickly, because I see we just have a minute left, some of the recommendations that our paper is going to pose is that, number one, there is definitely a need for African countries and also our regional communities, to enact data protection legislation that will enshrine these principles of protection of personal data that will be based on the respect for privacy. That is one. We are also looking at we are calling for African regional communities to put in place charters that will govern the ethical use of artificial intelligence. And a good example is the Council of Europe that has put in place a similar charter that gives principles on the ethical use of artificial intelligence, and principles such as consent and transparency, which is central again to protection of privacy. We are also looking to see and hoping that African countries will also put in place effective remedies, and whether these are judicial or otherwise, for the review of all violations that are a result of algorithmic data processing or decision making. And also one last thing that we also want to point out, and we hope not to forget, is that there was also need to have in place systems to ensure that citizens are constantly aware of their rights and freedoms online, and including the risks that are posed by the use of AI systems, and hoping that they will be aware of remedies to grievances arising from AI systems. So that is it in a nutshell, and we hope that you'll all be able to read more of the paper when it's finalized and it is published. So thank you, and over to my colleague if she has anything that she may want to add. If not, then we over to you.
Thank you again, Wakiko and Wakesho, for your interesting presentation. Again, I invite participants, if please you do have a question, you may either write it in the chat box, or you can either raise your hand, if I may be able to see. There are lots of people participating, so that I can give you the floor. If I cannot see your hand, perhaps you may unmute yourself and try to ask the question. Meanwhile, I have perhaps two questions for both Wakiko and Wakesho. The first one, which I think is on what was presented by Wakiko, and my question specifically is coming from my understanding of artificial intelligence, is that is referring to the theory and development of computer systems that are able to generally perform tasks that are normally requiring human intelligence, such as visual perception, speech recognition, decision making, etc. But the point for where my question comes from is the ability of artificial intelligence technologies, particularly certain algorithms, their ability to be able to make decisions on certain issues. With that understanding, then you mentioned that data protection in certain countries, there's adequate regulation. I first want to understand what you mean by that when you say adequate regulation. And then you went ahead then to mention that the laws that are used in these laws regulating data, we also regulate or also apply to artificial intelligence. This is where perhaps I'm having a difficulty, where I may want a bit of clarification, because in my understanding is that one of the challenges that are raised by artificial intelligence technologies when it comes to the issues of data and other things is that they may make certain decisions which you may not really find a human being to blame. In other words, this issue of moral responsibility, or what others would refer to as accountability gap, to say when these artificial intelligence algorithms or technologies make a certain decision that affect the rights of another individual, and there was no person who was in control or participating in the making of that decision, who then becomes responsible. And the issue of responsibility being very important, because the right to a remedy, for example, may even include the prosecution of the person who breached certain rights, say the right to privacy or any other protected right, as it were. But where you have now the use of artificial intelligence technologies, they may create that accountability gap, which becomes an issue. And I wonder then, when you're saying adequately regulated and the same laws applying to artificial intelligence, what that means. Then to Wakesho, my question basically refers to where I see that, and I totally agree with you. Your initial thoughts is that artificial intelligence technologies do pose, a threat to various human rights of African people, which I totally agree with. But I wondered, if perhaps that should not only be the end of the story, because I for one believe that artificial intelligence technologies, even in the era of, or in our aim of trying to protect data, may actually also enhance protection of human rights. And I'll give you an example of such kinds of technologies, at least if they are modeled after the African context. During the COVID-19 pandemic and lockdowns, and many people spending more time online, there was a hike, for example, in online hate, which you both mentioned, misogyny online, people, attacking each other and things like that, which are really terrible sometimes. If you refer to what sometimes we call Black Twitter, or what we call, others will say, or South African Twitter, there are a lot of things that happen there in that virtual world, which necessarily are difficult for any regulator, particularly human beings, to be able to be tracking everything that is happening. And we are having, for example, at the Alan Turing Institute at the University of Oxford, during the same pandemic, they developed an algorithm, an AI algorithm that can automatically detect hate online. For example, there was a spike in the hate against Chinese people, against people from Asia, because of the link which was being drawn between the pandemic and what was happening. And it was being terrible. And that system that automatically detects that helps then in the regulation of, or trying to suppress or delete, so to say, those kind of hate. So I wonder if those are not positive, perhaps, ways of uses of artificial intelligence technology that can not only protect individuals, but also enhance, our lives as Africans.
Okay, thank you very much for your question. So I hope you had completed. So I'll just answer your question. So you asked me, I referred to us having adequate regulation. I think what I meant was in relation to the situation that we had before, in which we did not have any comprehensive data protection regulate privacy. However, what I meant was compared to other jurisdictions within the East African region, which are yet to enact similar legislations, then in that regard, they don't have the probable standard that you would have to say that they have probably adequate regulations. Because if you look at regulations like the GDPR or even the Kenyan one, when you're for example, doing cross-border data transfers, they actually require you to do this with another jurisdiction that has competent or equal or adequate safeguard measures. So that's what I meant. However, what I also pointed out is, in as much as we
Sorry?
No,
I'm not sure if it was from my side. I think there was a moment where you froze, so I wasn't hearing you, but you may continue.
Oh, okay. So in that case, we might not have actual protection or implementation. On your second point about the accountability gap, when I was speaking, I did speak to having because AI relies on data sets, and it also relies on algorithms and machine learnings and things like this. And so it's important to have ethical considerations when you're making AI. So those are some of the things that you need to have. With regards to whether the legislation in privacy does call for privacy by design and all these things, and having you adhere to privacy principles, but the use of privacy and ethics is still another thing that we need to consider. And so in that regard, I would consider, in terms of where you're asking, yes, we do have all these things. Yes, we did try to make use favorable data sets, but how did we consider the things that call about ethical decision making? And that's why in my presentation as well, I said when it comes to things like, for example, content moderation, in as much as you would want to have this process totally automated, I did say, and I did allude, that it is important for us to still have human moderators, people who understand local context, people who understand local language. Because another thing is, you see, the way you have just said you have Black Twitter in South Africa, there is a whole social cultural environment that makes you, for example, understand one thing in one local context that I would not be able to understand, even though we, for example, would speak English. So even though, for example, I speak English in Kenya and you speak English in, let's say, DRC or Tanzania, because of local context and because of influence of what is happening within the ground, something that I as a human moderator might consider unethical, might consider violating content moderation standards, is not something that algorithm can be able to take into account. And that's some of this, so the accountability gap and the ethics. Then you asked who takes accountability. Then in that regard, I think first it's, there's this principle for if you've done everything that you could. So if you have, there's things that are justifiable responses. But with regards to that question, I think I would have to just look into it. But I think that the ethics around AI are something that we need to consider in line with privacy. So that would be my response.
So what I would say in response to your question is that, number one, you're absolutely right. There's a lot of benefit to the deployment of AI, and we're seeing that. So for us, the thrust is this, that as we're deploying AI technologies, AI systems, and all things AI, we just need to make sure that that human rights human rights is placed at the heart of the advancement of these technologies. That is one. And again, as you were saying very correctly, that as we put human rights at the center of deployment, at the center of design, at the center of advancement, then we should always keep in mind two very important principles. That number one, the need to make sure that there's that, the respect to individual agency and autonomy, one, and then also that, that we need to make sure that there are efforts, to keep all this innovation open, and, to enable their scrutiny also. And basically just what I'm just trying to say again is to make sure that we have, the human rights at the very center and as the very essence of design and deployment. I think, I will stop there.
Thank you very much, Wakesho and Muya, for your really interesting responses and presentation there. I totally agree with you and really happy to hear, because I'm of the same opinion, especially to start with Muya's response on the issue of the need for a human moderator. In my own field, we are calling it the maintaining of human control. The need to make sure that humans continue to be in the loop, particularly when it comes to making decisions that affect humans. And you know, Wakesho, your emphasis on a human rights-centered approach to the issue of regulation of artificial intelligence technologies and how they relate to data is something that I totally agree on board. And on that, I would like to perhaps quickly move on to the third presentation. And this is from Emmanuel Salami, whom I think have just joined us now. And it is on the ascent of AI in Africa, bridging innovation and data protection. I think this will perhaps, you know, nicely connect to the discussion here when we're talking about ascent, or maybe the rise of this particular issue of artificial intelligence in Africa. You know, bridging that innovation and data protection, which perhaps in my view would then be to broaden it to the issues of human rights protection. Emmanuel is a Nigerian trained lawyer with expertise in privacy, data protection, intellectual property, and information technology law. He is a member of the International Association of Privacy Professionals, and Emmanuel has experience working as a data protection advisor in Europe, where he has advised various multinational companies on data protection compliance. And he obtained his bachelor's degree of law in information technology and intellectual property from Leibniz Universität, Hanover in Germany. And he is a PhD candidate in IT, IP, and data protection law at the Faculty of Law, University of Lapland in Finland, where he also teaches data protection law to students. Emmanuel's doctoral research focuses on the impact of AI on IT, IP, and data protection law, and he has published articles in peer-reviewed journals, and both by African and European Union data protection law. Emmanuel, you are welcome. Please take the floor.
Thank you very much for the very kind introduction. I'm very happy to join this conference today. Firstly, I want to thank the organizers of this conference. I do think that this is a very great idea. The conversation on African data protection law could not have come at a better time. And it would have appeared before this conference that Africa was probably the only continent that wasn't really taking data protection law very seriously as a unit. And I think that I'm quite excited that we are having a conference of this nature. So I want to again, salute actually the guys, the team behind this conference, and I'm very excited to be here. Today, I'm going to be presenting my article titled "The Ascent of AI in Africa: Bridging Innovation and Data Protection." And to get straight into the conversation, let me quickly run you through my table of contents. Just a sec. So to run you through my table of contents, I would start with an introduction and definition of relevant concepts, after which I would embark upon a brief overview of selected African data protection laws, and take a look at some real-life case studies and examples of the deployment of AI in Africa. Afterwards, I would take a look at how some of these AI systems collect personal data, because I do think that it supports the appreciation of the data protection law consequences to firstly be able to see that artificial intelligence actually takes data, actually collects data. And afterwards, we would then consider the data protection concerns and remedies in the deployment of AI, and then some implications of inadequate data protection law regulation for Africa from an AI perspective would also be considered. I think that as a general background, it's important for me to state that my research takes somewhat of a pragmatic approach to examine how selected extant laws within the continent of Africa To be very specific, from the context of the African Union Convention, the ECOWAS Act on Data Protection Law, and the Kenyan Data Protection Act, from the perspective of these three focused legislations, I have tried to ascertain how ready we are as we speak for the ascent of data protection law across the continent of Africa. And so firstly, I think it's important to note that this is where the conversation for AI started from. Like for people, one of the reasons why AI still seems like something that is in the distant future is the fact that AI was a subject for sci-fi before, for scientific fiction, and it was something for the cinemas. But today, reality shows that AI is no longer in this realm. AI is now something that we are dealing with. It's now a reality of today, and not just a first world country reality, but also a developing country reality. To just, before going into the depth of the conversation, for instance, the diagram here indicates is a pictorial representation of the operation of an autonomous vehicle, for instance, and this shows intercommunications between autonomous cars, the Internet of Things, being the traffic lights, mobile vehicular clouds, telephones, and the actual cloud itself. And this actually shows that today AI is no longer something that we watch for 1 hour, 30 minutes in the cinema. It's actually a reality that's on our streets today that we are actually dealing with, knowingly or unknowingly. To go to my next slide, to define some relevant concepts, I've chosen three basic concepts, being AI, machine learning, and big data, to just define and provide some brief context. So from an AI perspective, it's typical. One of the definitions that pervades the definition of artificial intelligence over the years and across various authors is the fact that artificial intelligence is a simulation of human intelligence. Authors are very prone, particularly, for instance, Russell and Novick, for instance, define AI systems as intelligent systems that can perceive and act. And this definition actually flows across different authors, and it shows that there is an expectation that artificial intelligence, at least in the context of reasoning, is able to simulate human intelligence. There is also the concept of machine learning, which provides computers with the ability to learn without being explicitly programmed. Now, for me, I like to, in very simple terms, define machine learning as the ability for a computer to actually learn. Machine learning is the process through which data is taught, through which AI is taught how to actually act in specific situations through the use of data to paint or portray different scenarios. And there is also big data, which is popularly defined with the 3 V's definition, the high volume, high velocity, and high variety information assets that determine cost-effective, innovative forms of information processing. So typically, big data would be those voluminous categories of data that cannot be processed using the traditional processing techniques. Now, to move away from this concept, I would just like to give a very quick overview, very brief overview, nothing deep, succinct overview of African data protection law. And it suffices to say that I have attempted to break down African data protection law into 3 categories, which would be the continental regulation of data protection law, the regional regulation, and the national regulation. The continental definition, is reflected in the AU Convention, the AU Data Protection Convention, also referred to as the Malabo Convention. I would just refer to this subsequently as the AU Convention. This convention is yet to come to force as we speak, due to the inadequacy in number of signatures required for it to come into effect. There is also the regional, there are also regional data protection laws. For instance, there is the ECOWAS Supplementary Act on Data Protection. And then there is also the Southern African Development Community Model Act, both of which, in my opinion, do not really place so much weight in as far as data protection law is concerned. They may be persuasive, they may be there, but they don't really do much. There are also national regulations, which is the meat of African data protection law regulation, actually. However, out of about 54 countries in Africa, 23 of them are yet to have substantive data protection laws. But this also shows that more than half of the African countries have data protection laws, and which is a step in the right direction, to be honest. So I will be looking at the three focus legislations, like I mentioned previously, just trying to create a very brief overview of these three legislations, which will be the AU Convention, the AU Data Protection Convention, the ECOWAS Act on Data Protection, and the Kenyan Data Protection Act. So firstly, there are only 5 countries have ratified the AU Convention as we speak today. These countries are Senegal, Mauritius, Guinea, Ghana, and Namibia. The law requires 15 ratifications for the AU Convention to come into force. As we speak, 13 African countries have signed, but are yet to ratify the AU Convention, and these countries include Benin, Chad, Comoros, Congo, Guinea-Bissau, Mozambique, Sierra Leone, etc., etc. Now, as far as the AU Data Protection Convention is concerned, to my assessment, it's actually a decent data protection legislation. It contains the very basic traditional data protection law principles, but exempts the accountability principle. In latter parts of this conversation, I'm going to revisit the impacts and the importance of the accountability principle, not only for data protection law compliance, but also for compliance from an AI perspective. That's something that we'll get to in latter parts of the conversation. The AU Convention does not contain any detailed provisions on automated decisions. We will also address this in subsequent parts. It restricts the processing of sensitive data. The convention ought to be enforced by supervisory authorities. The convention also applies only to those processing activities that are carried out in member states. So, for instance, if you are monitoring or providing goods and services to residents of the African continent from outside of Africa, you are not covered by virtue of the provision of the AU Convention, which in my opinion is a very huge shortcoming. There is also an adequacy requirement under the AU Convention, but the law is silent about the means for its implementation. As a side comment, I would just like to say here that I think that an interesting feature for African data protection law is that countries are coming up a lot with adequacy requirements, but it's yet to be seen now in practice. This is something that would actually be realistic, because again, when you are talking about adequacy requirements, before you can issue an adequacy requirement for a country, then to be honest, political strength, trade, bilateral relationships are some of the things that will come into play. And then it doesn't suffice to just put a provision on adequacy requirements in the legislation. The question is, how do you implement? And I think that a lot of African legislations are really, really quiet about this, this practicality. To move on to the next slide, on the ECOWAS Act on Data Protection Law, this legislation is binding on this instrument is binding on ECOWAS member states. It doesn't apply, of course, to the monitoring and offering of goods and services to residents of the ECOWAS region. It stipulates for the adoption in member states. For instance, it stipulates provisions that can be adopted in member states. For instance, it encourages member states to set up supervisory authorities. It also exempts the accountability principle. Again, we would address this in subsequent parts of this presentation. And then the rights of data subjects, of course, I enshrined here in, for instance, the right to rectification, data portability, and other similar modern rights of data subjects under the purview or within the purview of data protection law are also included here. To take a look at the last focus legislation for the purpose of this article, it will be that of Kenya. And in Kenya, there is the Office of the Data Protection Commissioner. And interestingly, some minutes ago, someone shared with me information that the President Kenyatta had recently appointed a data protection commissioner for Kenya. So Kenya actually has a dedicated supervisory authority. This legislation also applies to both automated and non-automated processing of data. It contains basic principles, except, of course, the accountability principle. The distinction between this legislation and the African legislation and the ECOWAS Act is the fact that in the case of the Kenyan Data Protection Act, there are pockets of accountability principle required for specific points, specific data processing activities. But there is no general requirement to be accountable or to comply with the accountability principle. There are also monetary fines and prison sentences in place for violations of the Data Protection Act of Kenya. The Act also restricts processing of sensitive personal data. The data covers processing of the personal data of Kenyans and also applies to monitoring of goods and services to residents of member states by companies not physically resident in Kenya. And this is interesting because it means that if you're actually targeting Kenyans or Kenyan residents from, say, China, for instance, and trying to sell them goods, then you will be caught up, you would have to comply with the provisions of the Kenyan Data Protection Act. There is no requirement for an adequacy decision, which is actually a pragmatic provision, to be honest with you, from the perspective of the Kenyan Data Protection Law. And from this place, I would proceed to give examples of actual deployments of artificial intelligence in Africa. And from my research, there is Sophie Bot, which is actually an AI being used in the healthcare sector, which helps young persons to obtain information on their sexual and reproductive health. There's SciComp, which processes geospatial data from satellites and drones for monitoring farms. I think that this particular AI is something that is interesting because apparently for it to perform these functions, it will have a lot of sensors and a lot of cameras that would have a view of society, of the neighborhood, a view of people's houses, and a view of people moving around. And this is not very far off from the kind of processing operation that we witnessed with the Google Street View, for instance. And this is of course something that a conversation that we will come to in subsequent slides. There are also robots which have been very useful, particularly during this COVID-19 period in hospitals, airports, universities. There has been a wide use of robots for these purposes. There's also Data Prophet, which is used for predictive analysis in the finance sector. There is Number Boost, which is used in the AI sector for getting medical appointments for HIV-related ailments in the rural areas. Now, before I continue, I think that for me, it's very necessary for us to actually discuss AI in Africa from an African perspective. Mind you, in later parts of my conversation, I will be alluding to provisions of the GDPR. I would be alluding to some cases from the Court of Justice of the European Union or from some European court. But for me, I think it's very important for us to Africanize the discussion on African data protection law, to Africanize the discussion on the regulation of African artificial intelligence. And I've tried as much as possible to localize, except where you can't find literature, to be honest with you, to localize the conversation for the purpose of this presentation. And to proceed therefrom, the next question then would be, how do AI systems collect personal data? Like I said before, a lot of the time, the conversation on artificial intelligence processing data generally, then personal data specifically, is something that may seem vague to people, to the general public, because it's like, yeah, it's just artificial intelligence. How does it collect data? Blah, blah, blah. It's like, no, it doesn't contact with my phone. But the moment the artificial intelligence system connects with the IP address of your phone, for instance, it's in contact with personal data and it doesn't need to actually contact the person. So I think that this conversation is actually necessary and important to appreciate the data protection consequences of AI systems. So one of the ways through which artificial intelligence systems collect personal data, and I've chosen those systems that are quite relevant to the types of AI that we are dealing with here. One of such ways would be in the use of computer vision. And then computer vision actually equips AI with the ability to see and process images, to scan objects, scan documents, and to basically be able to observe its neighborhood. And the application of computer vision on any AI system is that the AI would probably be able to identify faces subject to security measures that have been put in place. We'll be able to identify faces, we'll be able to identify home addresses, identify houses, which, as we will discuss later, can actually lead to the identification of a natural person. AI systems also have objects. We also have sensors actually that will be able to identify objects, roads, users, and similar data. Most computer vision systems would rely on image sensors, for instance, LiDAR, radar cameras. It's interesting also to note that artificial autonomous vehicles, autonomous cars, autonomous ships rely heavily on the use of of sensors such as LiDAR or radar and cameras. There is also speech recognition technology, which is another avenue through which AI collects data by collecting the speech and being able to single out words or phrases in specific language formats, translate them into machine-readable form for the use of AI systems. Now, beyond this, the next slide would actually address now to the meat of the discussion for today, the data protection concerns and remedies in the deployment of AI. So one of the most, in fact, the most fundamental, before I continue, I think let me restate again that my presentation attempts a pragmatic approach to data protection, to the use of AI as far as data protection law is concerned. So I'm actually looking at how ready we are actually as of today, as we speak on the based on selected laws from an AI perspective to see how much the laws we have can actually help us achieve compliance. And for me, the most fundamental, of course, the most fundamental principle of data protection law, which is also most fundamental in the use of artificial intelligence, will be the lawfulness principle. And as a quick recap, the lawfulness principle basically requires that personal data should be processed on one of the 6 justifiable legal bases, which could be consent, performance of a contract, legitimate interest, vital interest, public authority, and one other thing I'm always forgetting. Now, if you take a look at the use of artificial intelligence, for instance, I mentioned, I think SciComp is the AI system that would be able to view, for instance, a farm from a geospatial location, and we'll be able to actually access the neighborhood and see houses and see people moving around if this is possible. Now, in the case of such an AI system, you would find out that it's very difficult to actually base it on consent. Let me take it back a bit. Now, the problem with the lawfulness principle is not with legal basis for the use of AI is not in the context of the person who has procured the AI for use in their life or in their endeavor. The problem, particularly with the lawfulness principle, is with the compliance in the context of observed data for persons who are just moving around, going about their businesses without even being aware that AI is being used in the location. I give you an example of SciComp, which is the AI system being used on farms from geospatial locations. Now think about it, that if the AI system has drones, has cameras and sensors that are able to actually view the community, view people moving around, and people are moving around without being aware of this, and their data is being collected. Probably their faces are being captured. In the cases of autonomous vehicles, their contact is being made with their phones, IP addresses, and their computer IP addresses without their knowledge. Their faces are being captured. Homes are being captured in the AI or in and by the AI system. Vehicle plate numbers can also be captured, and all these are pieces of information that could lead back to the identification of natural person, thereby making them personal data. Now, in this context, it becomes very difficult in the context of the observed data that has been taken from data subjects without their knowledge to actually decide or to provide the legal basis for that processing operation. Now, I will quickly run through the processing operations. You cannot say it's consent, right? You don't have the consent of an innocent bystander to collect their personal data. They are not contracting with you. There's no legitimate, there's no vital interest. You don't have a public authority. You are not complying with any legal provision. And for you to be able to rely on legal basis, you have to be able to do the balancing test and be sure that your interest as a data controller outweighs the rights, the natural rights and freedoms of the data subject. And now in reality, in practice, you will find out that it's impossible, actually. It's not, you cannot lawfully use the legitimate interest legal basis, because I do not believe that the interest of someone using an artificial intelligence system outweighs mine, who is innocently passing by, outweighs my rights to data protection law. And so that being said, it would appear that it's difficult, if not legally impossible, to find a justifiable legal basis to justify the processing of data, of observed data in AI systems. That being said, there is another challenge which could be in the context of anonymized data, in the context of data re-identification. So one of the requirements of the GDPR is that once data is anonymized, then you do not actually have, it doesn't fall within the purview of the GDPR. This is covered by, provided for in the GDPR by Recital 26, and is also a traditional principle in the focus legislations. Now you would find out actually that even though the law says that anonymized data does not fall within the purview of data protection law, you would find out that data re-identification is actually existent, and it's possible to actually re-identify apparently anonymized data and be able to single out natural persons. There are a plethora of issues and scholars who have worked extensively on this topic, including Paul Holm, Latanya Sweeney, who have published academic articles and conducted practical experiments on the point of data re-identification. And in such a case, when AI is processing perceived anonymized data that can lead back to the identification of natural persons, this poses trouble for the principle of for the lawfulness principle. Now, to quickly take a look at the remedies, possible remedies for this challenge, you can actually, to collect personal data, one of the first things I've proposed is the collection of personal data only from applicable persons. So this is something that goes back to the principle of privacy by design. If it's possible actually to design artificial intelligence systems in a way that the collection of data is restricted to only those places where they should cover and does not affect innocent bystanders in a manner that affects observed data, then we would actually not have much of this problem. Also, it's necessary to create appropriate laws. Another way to avoid this problem is to, by virtue of compliance with the legal obligation, amend specific laws or provide specific laws that permits the processing, legally permits the processing operation in AI systems in a manner that the processing operation in an AI system can be justified in law in the context of compliance with the legal obligation. And then if you're anonymizing data, ensure that data is truly anonymized to prevent the re-identification of data subjects that may bring about unlawful processing. To go to the second challenge that is identified as the transparency requirements, which basically requires that personal data subjects should be provided with information about the nature of the processing activities. Now, in the context of, while this is actually very easy or basic, in processing of activities where with the person, between the data protection, between the AI manufacturer and the person that has procured the AI for use, in the case of observed data and people who are innocent bystanders, particularly with AI that makes a lot of use of cameras and sensors, you would find out that it could get tricky to provide this information, the required data protection information. And one of the ways to actually resolve these disputes would be by using of signposts and radio jingles, town hall meetings to inform people. And the use of town hall, these approaches have been recognized by the Swiss Federal Supreme Court in the Idob versus Google case, which involved the Google Street View. And then for me, I've also proposed in my article an African solution, for instance, considering African traditional means of communication as a way of also providing information to data subjects. For instance, in those rural areas where AI is being used to provide medical help, medical services, it's possible to actually come up with robotic town criers who are stationed in specific places, probably on market days, right, to perform in a similar way to the traditional town crier system to provide information to data subjects. So I think that it could be helpful also in providing information to consider traditional African means of communication or providing information to resolve the transparency challenge that is identified here. There is also another data protection concern, which is purpose limitation, which requires that personal data should be limited to the personal data processing should be limited to the purpose for which it was initially collected. However, there is also data repurposing in the context of AI, which is something that happens a lot because of the possibility of AI to, through the machine learning system, to discover new insights from data and be able to process data in further lights. And the implication of this actually from the focus legislations, the laws just say, the focus legislations provide that, look, process data in relation to the purpose limitation principle, but they do not provide further to how this can actually work in the case of purpose repurposing of data. Now, if we take a comparative look at the provision of Article 6 sub 4 of the GDPR, it provides certain conditions, criteria, which have to be examined in the repurposing of data by a data controller, for instance, the relationship between the data controller and the data subject and similar provisions. I think that it's necessary for African data protection legislations to actually reconsider their provision in this context to be able to ensure that data repurposing is possible It's a possibility within the context of AI, but that also the law is able to step up to be able to regulate such eventualities. There is also the question of algorithmic bias, which is occasioned largely by non-representative data or non-representative developers. I give you an African example. The way people appear physically, largely in the western part of Africa, is different from how people would appear physically in the northern part of Africa. And so in avoiding algorithmic bias, it's necessary to ensure that there is a proper representation in the developers developing AI systems and also in the data that is being used. So you cannot use data that reflects Southern or Eastern Africa without reflecting the West and the North also. Because when the data, when the AI system is released, it will actually be biased against the non-represented data. And an example of this kind of a bias was reflected when in some facial recognition technology, it could identify persons of certain race and not identify persons of other races. And this was occasioned by the fact that people from a specific race were involved in the development of those facial recognition technology. So I'm trying to actually run through to also save time. So there is also the another concern is in relation to decision-making AI systems. The focus legislations basically forbid automated decision and do not provide more. Kenya only goes a bit further to say, look, if you're a data subject, you have a right to be informed of the automated decision made against you. You can complain and then request another decision from the supervisory authority. Unfortunately, the focus legislations fall short in the context of guaranteeing a human intervention, guaranteeing human review of automated decisions, guaranteeing a right to explanation, which would also lead to the opaqueness or of algorithms to be able to provide explanations. And then there is also the question of a right to generally contest automated decisions. And the data protection legislations, the focus legislations are actually very, very, very inadequate in this context. There is also the data minimization requirement, which basically requires that in processing personal data, only those categories of data necessary for the purpose of processing the data should be collected. Now, the problem here is particularly for those AI systems that make use of cameras and sensors that are able to view their neighborhoods. For instance, in the Google Street View case, in those systems that make use of a lot of cameras and sensors that view houses and view plate numbers and view people and view home addresses, then it may be actually difficult to actually to minimize data in this context, because they would most likely take more data than they should actually take. And the remedy for this, to me, would be ensuring that there's privacy by design in the processing operation, which ensures that these considerations are put into the processing operation from inception. There is also the accountability principle, which is absent, which requires that controllers should document the justifications for their processing activity. Now, this principle is completely not present in the focus legislations, although in Kenya, there are selective applications for specific actions. And the recommendation is that the accountability principle should be included in the laws to ensure that data controllers are bound to actually implement, to record and to document the basis upon which they have taken decisions, because the accountability principle, among other things, also ensures that data controllers are put on their toes, they're on check, trying to ensure that they stay compliant with the relevant laws. So I have created a graphical representation to depict the level of compliance across the continent with artificial intelligence, and yellow shows that there is.
Excuse me, Emmanuel, if I may please ask you to now conclude. I think we might be running out of time now.
Yes, I will do this. So this depicts the level of compliance in the continent, which shows that the level of compliance is very low. And I think this is my second to the last slide, which basically mentions the implications of not having adequate data protection laws across the continent. And one of the challenges would be that, of course, there will be human rights violations. There will be the risk of African countries being used as test centers for unlawful processing activities. We are already seeing a lot of traces of this. Companies coming to African countries to carry out processing activities that they ordinarily cannot carry out in their home countries that would be unlawful. And then there is also the trade inhibition problem, which would arise in the context of not being able to comply with the data protection laws of relevant countries, which may make it difficult for those countries to actually transact with African businesses. Thank you all for your attention. I'm sorry for running out of time.
Thank you very much, Emmanuel. I'm seeing some comments in the chat box. I believe we'll read those and try to also give you a chance to respond. But given our time, I would just want also to pose one to you. But perhaps you have to. We'll give you time to think on it while the maybe last presenter will be making their presentation. I must say that thank you for a very interesting and detailed presentation, and even your first approach of defining your how you view or understand artificial intelligence. The comment which perhaps I might want to hear from you, Emmanuel, is that when you refer to this as mostly a process of simulation of human intelligence, generally there are scholars who say that, to some extent, that the issue of saying machines simulating human intelligence may be perhaps misleading, particularly for purposes of regulation and how the community should react to some of these technologies. And the idea being that artificial intelligence technologies cannot, for example, simulate situational awareness, which is part of human intelligence. They cannot simulate value judgments, which can only be done by human beings, which is part of situational awareness. And reason why, even from the beginning, I said it is important in this discussion for each of us to at least articulate their understanding of artificial intelligence is that whatever recommendations and proposals that we make, for example, when you make that important discussion about data protection, concerns and remedies in their development, that particularly I also feel that it's affected by how and what you understand to be artificial intelligence and how it works. For example, though, as a question which I will also maybe have a time to comment on, because I believe your presentation may also be linked to the next speaker after they've also made their presentation, is the idea where I ask, should be the first or the starting point, should the starting point be perhaps whether are we okay with machines attempting or even succeeding in doing so, simulating all human intelligence? What I mean by that, are we all okay with artificial intelligence carrying out all tasks that are normally meant to be, done or taken by human beings? I believe that clearance at the beginning may also then tell us what we need to regulate and what we may not need to regulate. And this links perhaps to the previous conversation by Moya and Wakiko on the aspects of maintaining control on certain aspects as far as decision-making is concerned. Talking of decision-making, I think this brings us to the last presentation by Alon Lev Al-Khalei. Please forgive me if I'm butchering your name. On the issues of liberty versus algorithm, exploring the regulation of automated decision-making and profiling in an era of big data and ambient intelligence, a European and South African perspective. And Alon Lev Al-Khalei is an attorney of the High Court of South Africa, holding an LLB and an LLM in information and communications. Currently, he's a technology law advisor at the End Code, and his work involves advising startups and establishing technology companies on contracts, compliance, and legal risk, as well as conducting research on emerging issues in technology, law, and policy. His research interests are in data protection, privacy, and ethical AI. I must say that's interesting because ethics of AI is something also that I have a huge interest in. Alon, you have the floor.
Thank you very much, Dr. Thompson, for that introduction. Also, thank you very much to the organizers, the other panelists who have all been brilliant, and of course the attendees. I'm very pleased to be in this forum. It's a very timely conversation and discussion, and I hope that I can add a few interesting thoughts. Just to give a quick answer to your question as to what I view AI as, I will not answer it from a technical point of view. That's definitely not where my speciality lies, but from a more societal point of view, I view AI as a tool that ultimately should be a natural extension of humans. It should serve a purpose in furthering human rights, serve a purpose in furthering human liberties and human enjoyment, actually. And this is, it's kind of where some of the issues come in when it's used for commercial purposes. Sometimes the rationale might shift to different places, and I think that's where adequate regulation and adequate discussion about the use of AI is extremely important. And I mean, just on that note, looking at the OECD's recent recommendations on AI and the explainability thereof, which interlinks directly with decision making and profiling, I think it's obviously a very good step, and I'm definitely looking forward to seeing how Africa responds to these policy recommendations. Saying that, my presentation, as you've introduced already, it revolves around the regulation of automated decision-making and profiling, and it's contextualized in an era of big data, which we are experiencing already today, and ambient intelligence, which I'll get to in a moment, which I view as coming tomorrow. But before beginning, I would like to just start off with just quickly describing how this presentation will go. I'm going to start off setting some context. I will then move into the different technologies that we're referring to, automated decision-making and profiling. I will then briefly, because I'm very limited with time, speak about what I view as a two-prong approach to regulation under the European General Data Protection Regulation and South Africa's Protection of Personal Information Act, which as of July recently came into force and which will be fully active as of July next year. After that, I'll just speak on some findings which have already been touched on by many of the other panelists, and finally some recommendations. Okay, in opening the presentation, I'm going to just quickly quote the opening to my article research, and it goes as follows. Whether or not we are conscious of it or care to acknowledge, humans are organisms. Organisms are algorithms, and algorithms can be hacked. Now, I've taken this from a historian and philosopher called Yuval Harari, and I definitely recommend that everyone looks at his work. Okay, so I've already mentioned we're living in a world of big data today, and we're going into a world of further connectedness, looking at 5G. And yeah, let me quickly just define or provide a definition of what big data is. Big data may be understood as novel ways in which organizations combine diverse digital assets and use these to extract hidden information and surprising correlations from the data. When we're looking at ambient intelligence is a European conceptualization. Other conceptualizations are in the form of ubiquitous computing or ubiquitous networking. And basically, in a very simple form, what it's referring to is an interconnected world, which we are already beginning to see. And the key here is that the world would be smart and actually reactive to data subjects and to the rest of the environment, reactive to one another. And that's quite key for automated decision-making and profiling, because automated decisions will be made constantly, and so will profiles. And ultimately, which I'll get to now, they'll feed into one another. And they do have potential to obviously prejudice human rights. So on that note, what issues arise from automated decision-making and profiling? Some of these have already been touched upon, but we see things like algorithmic errors, discrimination in decision-making, loss of individual autonomy, which is a very interesting one, where I see those with enough data and who can make these automated decision-making and profiles on people can ultimately manipulate or adjust or shift angles of our emotions, our perceptions, our behaviors, our preferences, and our habits. You know, to make this quite personal, I don't know who uses YouTube here, but if you've ever noticed, you might go down a week or two and all of a sudden you've been dished something and you've developed a new interest. And we actually, as human beings, we are very malleable, and it's something to be aware of. And sorry, I just clicked over to the next one there. But let me move on from here. I'll just leave off on, just to set the context right. And I do believe it's a powerful thing to keep in mind. Organizations are learning to know us better than we know ourselves, right? And let's keep that in the back of our minds. So what do I mean when I refer to automated decision-making? What I'm referring to here is the arrival at a decision by a computer system that's made autonomously without human involvement. Okay, I've put an example here for the attendees to understand exactly what that might mean, as simple as it is, but it would really, an example would be an automated home loan application or an automatic quotation for insurance. In these cases, you can submit data, it can collect data, and it can reach the decision without human involvement. Profiling, a little bit more complex, but a working definition would be the process of using algorithms to construct probabilistic knowledges, which would be inferences or predictions, through the discovery of correlations in large data sets, and which knowledge may then be applied. And this is where the profile would come in and where it would link with automated decision-making. Now, it's important to keep in mind that profiling may be done upon an individual or upon a group of data subjects, and those profiles may be interchangeable. The POPIA in South Africa does not define profiling. GDPR does, and it reads as follows: any form of automated processing of personal data consisting of the use of personal data to evaluate certain personal aspects relating to a natural person, in particular to analyze or predict aspects concerning the natural person. So an example of a profile, again, I'm going basic to make it palpable, but a music streaming service, whichever one you use, may over time generate a profile. It will understand your musical interests. And beyond that, the more data it has and the more profiles it compares your profile to, it will eventually be able to also infer your personality and emotional states. And on that note, I mean, Spotify just the other day actually registered patents on that exact basis. Okay, so I want to just quickly in 1 second describe that automated decision-making and profiling are distinct processes, but they do take place together very often, okay? And it's important when it comes down to the presentation that you'll see later, where the interpretation of the provisions in the GDPR and the POPIA, as well as any other laws that contain similar provisions, the interpretation of what these technologies mean can definitely impact how they interpret it and what rights data subjects are left with. But just to make this palpable again, an instance where an automated decision and a profile may be interrelated would be you're driving down the highway, there is an automated traffic camera, and at the first time you're driving over the speed limits, it automatically gives you a fine. A year or 2 or 10 goes by, and this camera has now developed a profile of you. It understands your driving habits, and it has developed a profile. The next time it finds you, it may potentially apply that profile and be like, okay, you've sped way too many times. We are now going to fine you a lot higher, or you've never sped before. So because this is your first time, let's make it a bit lower. So in that case, a profile is being applied during the course of a decision being made. Okay, now under the GDPR and the POPIA, and I would go as far as to say under many other data protection laws, there'll be a two-pronged approach to regulating these processes. The reason I say that is because the laws, at their essence, have general principles or conditions for processing, grounds for lawful processing, and obligations, principles and conditions for processing. These are also called grounds for lawful processing. They are data subject rights, of course, and obligations that responsible parties and operators in South Africa or in other jurisdictions, controllers and processors would be subject to. And in these cases, this traditional framework doesn't always directly regulate these technological processes, but they have various use cases, which I will get to on the next slide, that can show that they do have use case to help empower data subjects, but it's not directly dealt with. The second prong, or the second lens, which both of the laws have, are specific provisions that relate to automated decision-making and or profiling. The reason I say and or is because the interpretations thereof might vary, and in some cases that only applies to automated decision-making. Okay, so when we're looking at the first prong, again, a lot of this has been covered already, but what you have are basic principles and rights that data subjects have, such as notification rights, access rights, the right to object, the right of explanation. And I'm not going to go into detail in all of this now. I'm happy to share the slides and answer any questions after the presentation. But the point I want to get to is that there is most definitely a certain level of recourse for data subjects through this first prong. So, for example, if I can just pull something out, the GDPR does provide a right of access within its traditional data subject rights, but there are limitations, and that's really where the interesting things come in. So Professor Moritz actually referred to, the economical balances, and the GDPR explicitly states that access to a profile or a record of data that contains an automated decision shall not adversely affect the rights and freedoms of others. And quite frankly, that can be extended to intellectual property rights of organizations as well. Similarly, under POPIA, we see very promising provisions. As far as I know, and I'm happy to be tested on this, but there has not been any formal case studies where we can see how this will work in practice. But POPIA has promising provisions where it requires responsible parties to retain personal information that is being used in a decision-making process. And this is obviously to enable access. So I want to just use this example to point out that the first prong of data protection laws does have use cases. What I'll get to next after the second prong is, under findings, we will see that there are some fundamental lacunas or gaps or issues with these data protection laws, some of which have already been mentioned already. And what I'll be arguing really is that it limits those use cases. And so I'm going to pause there and I'll move on to the second prong for now. So remember, the second prong is specific provisions in these laws that have been dedicated to regulate the subject matter. As you can see, these between the POPIA and the GDPR, both of them applying to automated decision-making. The GDPR slightly nuanced in that it applies to automated decision-making, including profiling. I'm not going to read them out now, but we'll break down the impact of the wording of these provisions shortly. So what we're seeing, and again, I'm yet to see any court in Europe at the moment have to determine or provide clarity on these matters. And obviously in South Africa, POPIA is not fully in force yet. It will be fully active as of July next year. But so at the moment, this is very academic and very technical. And obviously I'm waiting to see how this works in practice and how it's interpreted. But under the GDPR, there's a very big issue in that under that Article 22, whether the provision constitutes a prohibition or a right to object is currently unsettled. And there's various academics that have different opinions on that. Now, obviously, if it's a prohibition, that's great for data subjects. If it's a right to object, well, firstly, they're going to have to become aware that it's even happened and then go through that process. Under the POPIA in South Africa, it's clearly prohibitive and it's an outright prohibition. The next big question is, do these provisions actually regulate profiling in and of itself? And again, both of these cases are unsettled and open to various interpretations. What I argue and what various other academics argue is that no, profiling in and of itself is not regulated. But let me just give a bit of detail. Under the GDPR, Recital 71 considers a profile that is constructed by automated means as a decision in and of itself. And on that basis, one could argue that, yes, profiling is regulated. However, it's important to keep in mind that recitals they're not legally binding directly. They serve an influential purpose, and they obviously will be taken into account by a court that's interpreting one of these matters. Under POPIA, what I'm arguing is that the right does not apply to profiling per se, but rather to automated decisions that have been reached by applying a profile. And there's a very big nuance here with interpretation that again I'm waiting to see. But how this ends up being interpreted will obviously severely impact data subject rights down the line. If we look at the other elements of the second prong, both of them have exceptions. So whether or not in the GDPR it's a prohibition on right of objection, in either case, there are certain exceptions. They're similar, both of which have an execution of a contract or where it's mandated by law. The GDPR also provides that where a data subject explicitly consents to automated decision-making taking place, then that initial provision, the prohibition or right to object, won't apply. Now, importantly, when that is the case, responsible parties or controllers will be required to implement suitable measures. Okay, now in South Africa, it's actually great to see that there is a real right of explanation as to sufficient information about the underlying logic of the automated processing. Under the GDPR, even though in the first prong there is a right of explanation which has some limitations, which I'll get to shortly, in the second prong, a right of explanation doesn't actually exist. It has been mentioned in Recital 71, but it is not an operative provision that can be used by data subjects. Now, if I move on to just looking back at the first and second prong, what key issues arise? And this is really going back to what the other panelists have been pointing to as well. A big one, and if I reference to Professor Moritz again, AI is often at odds with the principles of data protection law. Now, data protection law is foundationally based on the definition of personal data. Okay, personal data is any information that relates to an identifiable natural person. In South Africa, it extends to juristic persons as well, so companies. Re-identification has also been mentioned as an issue, and I'll get to that now. But what I want to say here is that none of the prong one rights, those traditional data subject rights and principles, apply to de-identified personal information or group data. So if a profile is made upon a group of people, whether that's all of the people that are lawyers in South Africa, or whether that's all of the males in Africa, or any group, a group is not a person. So that would fall outside of the scope of the definition of personal data. The second issue relates to transparency, and this intertwines with the principles of data protection law. And what I'm really speaking to here is that the focus in our current data protection laws is on the collection stage, not the usage stage. And what's happening is that the laws have been drafted in such a way that they place focus on the traditional ways of obtaining data, where you'd go to a website, you'd accept a privacy policy, and X, Y, and Z data would be obtained. But what they're not pointing to, or what needs to be pointed to by regulators, is that the law should be applying to data collected through a process of data mining. Okay, that is what's happening here in this big data world, where new knowledge, which could be deemed personal information, is always being created. But what really is an issue here is that in that prong one, in the traditional rights, very often notification rights are drafted in such a way that they apply to at the time of collection. So at the time of collection, you engage with a service provider, you engage with a platform, and at that moment in time, they may not be mining your data. It's the initial stage. And basically, there's a big issue rooted in transparency that needs to be addressed. Similarly, with notification rights, a lot of the notification rights are drafted ex ante and not ex post. So after the fact, you actually cannot be notified that automated decisions are being made about you, profiles are being generated. And the big argument is, how does one invoke their rights if they are not aware that they are being profiled or that automated decisions are being made about them? Just to recap on the actual tidbits of the regulation, there are potential use cases for traditional data subject rights and principles, but they are limited. regarding prong 2, we've seen that there is uncertainty as to the actual interpretations. Another limiting factor is that in order for that prohibition or right to object, whichever way it's interpreted, to exist, the effect on you must be significant and there must be a legal effect. So the use cases in which you can rely on those provisions are limited. And of course, the suitable measures that responsible parties or controllers are required to put in place are only required when an exception is applicable. And going back to the exceptions, we were looking at when a contract has been concluded, when it's been mandated by law, or under the GDPR when you have consented. So I'm going to just quickly try and wrap this up now and just look at going forward. I've already mentioned that we need to focus, and it's not my idea. There's an academic named Tal Zarsky, and he speaks about regulating usage as opposed to collection. And we've spoken about how collection is going to take place, and quite frankly, collection needs to take place in an era of big data. The other panelists have pointed to the prejudices that can come about when algorithms are fed limited data. So the principle of minimality doesn't work. Collection is taking place and beyond those minimal principles. And what really needs to happen is that we need to focus on how is data used and what rights to us as data subjects have at those later stages. Other recommendations would be requiring sui generis or dedicated laws that are not foundationally based around the concept of personal information. We need laws that consider de-identified information, group information. And these laws, I would argue, need to be enforcive and not just aim to induce behavior. Lastly, it would also be a good idea to have transparency enhancing tools. So we've already got privacy enhancing tools that are being widely spoken about and implemented, but transparency is an issue that I've identified. Transparency by design is a principle that should be looked at in these new laws. And lastly, external interventions. What role can our data protection authorities play here? And I would just quickly point to some of the existing mechanisms within the laws until future laws have been created. And those would be things like prior authorization and codes of conduct. Our regulators, for the most part, are empowered to require prior authorization in certain circumstances, which they can define, and they can create codes of conduct, and so can industry. So it should be really, there should be a push for more after the fact transparency and after the fact, rights of data subjects after the fact. We need to be able to see, look, hey, I want to know what profiles you have on me, what automated decisions have you made about me? And data subjects need to be empowered in that regard. And then I'll conclude by saying that instead of stretching our current laws in their form, we need specialized legal and transparency enhancing tools that can rebalance the information asymmetries between those who can see, the organizations who have all the data, and those who are being seen, the data subjects. Thank you.
Thank you very much, Alon, for your very surgical presentation and very interesting points there. I would want, because I think we really are short of time now, to Hassan just to ask you some questions. I have 3 of them. And I think also the previous speaker, Emmanuel, will be able also to make interventions and also comment on some of the issues. I find your presentations, really related. So my first question was on the issues of, when you talked about automated decisions and how the definition which you provided for, I wondered if, because in my understanding, I wondered it may be different, if you see a difference between automated decision-making processes through algorithms and autonomous decision-making processes of algorithms. The issues which I have, at least in my understanding, though they may be related, they're a little bit different, with the other one actually a bit severe, that is autonomous decision-making. Automated, at least in my understanding, when we're dealing with AI decision-making, is you have at least a structured environment. There are set parameters, and this has been happening. Others actually argue that that's not actual artificial intelligence. Like, it's been happening for a long, like things like such as landmines. A simple issue that if a certain thing of a certain weight steps on you, then you blow. That decision is said to be automated. If you, a kettle, or if you're trying to toast your bread, if you put it after such a time, it will eject the bread out. Automated decision. But when it comes to autonomous decisions, this goes beyond that. It is the environment is a bit more unstructured, and decisions which are made by these technologies becomes unpredictable. So you can't predict how the particular AI technology will respond to certain given facts. And they raise, of course, different challenges. So I wondered if my understanding and yours in that regard are actually different. Yes. Then you raise a very important aspect on the issues of that sometimes the focus is on when you're talking of collection of data is at the collection stage, but what perhaps happens when that data is being used and perhaps post-use, after it has been used. So here I wanted to also maybe to ask if you think that could be an issue of recommendation, or it's something which you may want to look at on the issue of explainability and interpretability of decisions that have been made by these either automated or autonomous, and how that is important for people who are affected by those decisions. And lastly, the question which I have, which is more comparative. It's on the issue of profiling. I wondered, in Europe, in the USA and other countries particularly, the issue of profiling when autonomous systems collect data has been raised particularly in issues when it comes to, for example, issues of racial profiling in policing and the criminal justice system. Like, there are AI technologies, for example, which people have attempted to use in bail assessments. That's, you submit someone's data to whatever, which then decides whether that person may attend court or may not attend court, which then makes a decision as to whether that person must be granted bail. Issues of access to economic services, loans and other things like that, your data is used then to make that decision as to whether you qualify for a particular credit or not. Yes. So I wondered whether you see those profiling issues that have arisen on the global north, I don't know which, still or will still be problematic also for the African continent with the same severity, and if also there may be need for recommendation regarding that.
Okay, thank you. Thank you very much. I'm going to try and answer those as quickly as possible. Firstly, we're on the same page. It may have been an error of mine, but the rights, the prong 2 rights in the GDPR and the POPIA refer to solely automated decision-making. So the prong 1 rights, which are general data subject rights, general principles for processing, and general obligations, those would apply to everything, including merely automated decision-making. But the intention of the legislature, as far as I understand, in the second prong, where those specific provisions, the use of the word solely automated definitely is pointing to exactly what you're referring to, autonomous decisions. And I guess in the context of a very connected world, those would be happening all the time. Regarding the second question, I do think that if I call them ex post rights, the rights after the fact, enabling and empowering data subjects after they have been profiled or after an automated decision has been made, those are definitely very important. And something that I've thought about, it may be a bit far-fetched, but if one, just in the same way that you could log on to file your taxes and see your taxes, one should be able to potentially actually, from a glance, in a very confidential way, understand which controllers are processing your data, which ones have recently made an automated decision about you, which ones have made profiles about you. And there may be various mechanisms, ones that are probably a lot more practical than that, but focusing on after the fact is definitely a priority. And just regarding your third question, most definitely AI justice, if that's what you call it. I don't know at what point of course, that will come to Africa eventually. And I think if you zoom out from that, the same issues about explainability arise. And that's where solutions, some have been posited that are called counterfactuals. It would be the most simple way to explain to you why something has taken place without giving away the logic or our trade secrets in the algorithm. So the use of things like counterfactual explanations are very important. And I think they're going to be just as relevant here in Africa. I mean, Africa's technology, economy is booming and things are speeding up very rapidly. And I think that it's going to catch up very quickly with Africa, and that we're going to need the same form of thought processes.
Thank you very much, Alan. With that, Emmanuel, are you there? Would you want to briefly just make some remarks? Actually, we are a minute after our allocated time. If you can briefly just make some remarks if you need to.
So do you want me to make remarks about the comments you made previously about my presentation?
Yeah, if you have to, you can actually say that's some nonsense. I don't want to respond to that.
No, of course not. No. So I do think that the conversation you said, particularly in the context of the definition of artificial intelligence, is actually very interesting, and it's a feedback I get a lot. I think every time I submit an article to a journal, I get back that feedback that revolves around strong AI and weak AI. And I think it's actually very interesting, and it's a real conversation, right? Particularly from the context of, I think that when you talk about artificial intelligence systems being able to actually independently and consciously have a mind of their own and do stuff on their own, this would be in the context of strong AI. But when we are now talking about artificial intelligence systems that are actually just basically for specific purposes, these guys cannot think on their own, they are not dangerous, they cannot. And these are the kind of artificial intelligence systems that we have more of in the society. This is the reality where we are today. And I think that, to be honest with you, I see your concern about the risks that could flow from strong AI, from AI being very conscious and having a mind of its own. But in the same vein, I do think that at the end of the day, regulation comes in a lot, plays a huge role. For me, I would go for strong AI anytime, and for AI being able to actually play the role it's playing, because the advantages for me from research actually far outweigh the possible risks that may arise from AI systems. So while I think that there's a definitional problem, to be honest, particularly in the context of the reality of where we are today. If you're saying it's a simulation, is it really a simulation today? To some extent, to the extent of simulating intelligence, but of course not to a consciousness extent. But again, I would not discard of the old concepts like that. I think it suffices to make a distinction between strong and weak AI, which is what I should actually have done to prevent this conversation, to be honest. But yeah, I would not discard entirely the definition. But of course, I agree with you in the context of consciousness of AI and all of that. Thank you.
Thank you very much, Emmanuel. And with that, perhaps I may even add that, as you're saying that on the issues of distinction between strong and weak AI, others actually have emphasized also the distinction between good AI and AI for bad. That one that is meant for good things, particularly in Africa, where we're talking of production and economic development, and those actually that will harm us. And you have made really important points which I've taken into account, and the same with other presenters, recalling what Professor Morris was talking about when he was looking at this comparative approach from what is happening in Europe and what is happening in South Africa, in Africa, so to say. And his recommendation, for example, where he talks about consideration for a specific regulation of AI on a regional level, given that it appears that there are no specific regulations at a particular moment. I found that to be really an important point, especially when he says that after mentioning that artificial intelligence in general maybe seem to be at odds with data protection laws, and this is a very important point. Usually in Africa, we try to react to things after the fact. And as Alan really just indicated, artificial intelligence will continue to grow in Africa. This may seem too technical, too boring sometimes for people to be discussing this, but I think it is a bad idea for people to wait and have to react to things. The idea is to understand issues now and try to properly react in terms of regulation. And by regulation, this is not only the law, but also taking into account ethical values that are critical. And this is what also was being emphasized by other panelists, Wakiko and Wakesho, when the issues of what are the values that are also relevant in terms of ethics to regulation of these AI systems. And Wakiko and Wakesho also made also another interesting, among other points in their paper, about issues of having or adopting a human-centered and human rights-centered approach to the issues of AI regulation and data protection, something that we should take to heart. Of course, in conclusion, we had also Alan in his discussion of automated decisions, issues of profiling, and concerns that arise there, and actually some of the recommendations that can help us all in this particular regard. Particularly, the important point that, of course, whilst artificial intelligence systems are able to collect data, is rightfully explained by Emmanuel in certain ways. The focus should not only be at the collection stage, but also try to look at the usage stage and after use, and make sure that there are always remedies to this particular issue. That's how I would conclude this particular panel, and it was a pleasure listening to all the panelists, and thank you very much for taking all your time. And with that, I would want to also apologize to Claire Niwe for taking 7 minutes more than what was allocated to us. Thank you very much.
Thank you very much, Thompson, for facilitating the process, this session. We had very interesting conversations. It's indeed timely. It's a necessary conversation. It's coming up at a very crucial time when as African countries, we are embracing this artificial intelligence, and we are seeing that indeed there is an impact on the right to privacy. There's a lot of data that is being collected, stored, shared, and processed using this artificial intelligence. So it is indeed interesting that we have had to include this discussion in this conference, and I know that it has generated a lot of interest, and there is going to be a lot of engagement around this topic. This is not just the end of it, but it's a continuous engagement, and more of this will be happening. So thank you very much to our presenters for the elaborate presentations. I know the 15 minutes was probably not enough for you to discuss everything that you have in your paper, but we thank you very much for the important points that you managed to raise within the time that was allocated. Professor Moritz, thank you very much for the presentation. Ladies Wakesho and Wanjiru, Emmanuel and Alon, thank you very much for the time that we have spent, and also for sharing the great insights with us. So tomorrow's session, which will be the last day of the conference, we'll have two sessions again. One, the first session will be at 11 o'clock South African time, and the last one will be at 1400 hours South African time. So the first session will be looking at vulnerable groups. We're continuing on the topic of privacy and data protection, but we'll focus on women, children, LGBTI community, and also look at beneficiaries of social assistance. And then in the afternoon, we'll cover 3 areas, which is COVID-19, freedom of expression, and cloud computing, and then we will wrap up the conference. And then tomorrow again, we'll be asking you to evaluate this conference, what you feel about this conference, whether it was useful to you, whether it was organized, such questions. But for today, I also want to thank my colleagues, Maristela Simiyu, Tomiwa Ilori, and Simpiwe Kumalo for assisting us behind the scenes. And thank you everyone for your participation, for joining this conference, from the first day on Monday, and we hope that tomorrow as we wrap up, you will be able to join us again. As for the meeting details, the details are the same. We'll use the same details, but we'll also share them in the morning tomorrow. Thank you very much. Good night. If your time zone is the same as mine. Thank you and goodbye.